Okay, we're back for the lunch break. Let's begin with our next witness. Public counsel, you may call your next witness.
Public counsel calls Jordan Seaver.
Mr. Seaver, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated.
What is your name?
Jordan Seaver, Jordan Seaver.
By whom are you employed and in what capacity?
The Office of Public Counsel as a policy analyst.
Did you prepare rebuttal testimony that's marked for identification as Exhibit 204 for purposes of this hearing?
I did.
And would you have any corrections to that testimony for it to be your testimony here today?
I do.
And I should say, or changes as well.
Yes.
And what are those revisions you would have?
So there are a handful, starting on page 6. And this is the highly confidential version. I don't know if the page numbers differ from public or confidential, but
They should not.
okay.
Is any of the information you're about to modify confidential or highly confidential? Because
I
there are
don't-
3 versions.
I don't believe so.
Okay, if you'd go forward then.
So the first one on page 6 at line 4, it should read, yes, comma, I believe that, and then insert the company. The second, again on page 6, line 25, the company and has should be changed to had, H-A-D. Same line 25, the third word from last is would, should be changed to could. And then line 26, at the end of that sentence that resumes on line 26, started on line 25, I have a footnote insert. Due to a filed stipulation and agreement in case EA 2023-0286. And I don't believe that this is confidential, but I will look to anyone. It's about the solar facilities and the stipulation and agreement.
As long as you're not going to reveal what the cost of an individual
Nope.
facility was, then I
No.
don't think there's an issue.
Nope.
You want to look at it first?
Maybe I should, just, can't unring the bell, right? Thank you.
It's right at the bottom there. Okay. Okay.
Thank you for providing your assistance.
So to resume, I believe I left off with removes the CASS, C-A-S-S, county solar facility, comma, the immediate cost of the solar facilities will differ from costs used in my calculation, period.
Are those all the revisions you have for that, for Exhibit 204 to be your testimony here today?
No, there are 4 more.
Okay, what is the
Small
next
ones.
one?
On page 7, line 4, after the highly confidential information, there's a comma, and then it says, and it should be changed to costs, may, and then it says be higher, and that should be stricken and changed to differ. Then,
I apologize, can you maybe say that one more time?
Yeah. So I'll read the sentence and then I'll read the changes. I'll read that part of the sentence. And it may be higher once the CCN is. It should read, and costs may differ once the CCN is. And then page 7, line 8, the last word is witnesses, and it should have an apostrophe to denote possession. And then the last one, same page 7, line 18. It says of retiring Rush Island early with continuing to operate Rush 4 Island, 4 should just be removed. And those are all the changes.
With those revisions you just provided with those revisions to Exhibit 204 that you just provided, is Exhibit 204 your testimony here today?
It is.
I offer Exhibit 204.
Anybody object to admitting Exhibit 204, the rebuttal testimony of Jordan Seaver, onto the hearing record? I see and hear no objections. Exhibit 204 is admitted onto the hearing record.
I tender the witness for examination.
Is there any cross-examination from the commission staff?
Just very, very briefly. Have you been here for the testimony this morning and yesterday from the company witnesses?
Yes.
And do you recall Ameren's, Missouri's statements that many court cases found the not going out and getting a permit to be reasonable?
Yes, that was earlier today. Yep.
You point and discuss the Webco case in your testimony, correct?
Yes, I do.
Are there other examples of cases like that? And just for the brevity of time, if we wanted to learn more about them, where could we look?
There are. They're not included in my testimony. I learned about them after writing my testimony, but there is an exhibit entered already as exhibit, let me get this right. (200), which discusses the dense pack project of Detroit Edison Power Company. And then there is also the case of Coyote Station. I believe it was the Ottertail Power Company, is a similar case. And then there are cases referred to that I don't know specifically, so I can't provide you the names or anything, that were given or that were mentioned in the give me 1 second. The 2002 News Source Review report to the President by the EPA, and the cases mentioned are in comments by UARG, UARG, and other comments from other interveners, but that's the one that I remember specifically.
And just to clarify for the record, is the UARG that you referred to in that document the same one that Ameren has been referring to in some of their conversations about the air control group?
Yes, yesterday Mr. Whitworth mentioned the UARG and its activities. Yeah.
Okay, thank you. I have nothing further.
Any cross-examination from Ameren, Missouri?
Yes, Your Honor, thank you. Mr. Seaver, you are not an engineer, are you, sir?
I'm not.
Have you ever been called upon to decide when some Clean Air Act requirements would apply to a facility?
I have not.
Your degree is in philosophy?
Both, yes.
True or false, sir? When you filed with this commission your rebuttal testimony, in this case claiming that Ameren was imprudent for violating the PSD rules, you had no understanding of what those rules were, did you?
Prior to this case, no.
And you've never been asked to testify on whether an electric utility had acted prudently, correct?
No, I have not.
Those cases that you just mentioned in discussion in passing with Ms. Mayer's counsel for the staff, did any of those involve application of the Missouri State Implementation Plan?
The two that I specifically mentioned do not.
Did any?
I don't know about any in the comments from UARG because, like I said, I don't know the specific cases of those. They're just insinuated, mentioned.
No further questions. Thank you.
Any commission questions? I hear none. And I have well, let me ask this. Is public counsel is asking for a prudence disallowance because of prudence, is that correct?
That is correct.
But that relates more to the harm issue, correct?
It is, I wouldn't call it the harm issue. I would say it's 3B that it relates to in my testimony. But I do tie the 3B to 3A simply because 3B would not have occurred if it were not for the 3A issue. And so in discussing both, I'd say it relates to both, although the calculation comes from information solely related to 3B.
Okay, I'll hold my questions, my substantive questions for 3B. However, I'll go ahead and ask the parties, is there any recross based upon? Okay, I see none, and I'm assuming no redirect either. All right. Thank you, Mr. Seaver. You can step down. Okay, we are going to now begin issue 3B, which is were Ameren, Missouri's decisions regarding whether to continue to operate Rush Island instead of retiring or retrofitting it with flue gas desulfurization equipment reasonable and prudent? If the decisions were not reasonable and prudent, were customers harmed, and if so, in what amount? The first witness is Mr. Mitchells. Would you raise your right hand to be sworn? Didn't have to stand up, but that's okay. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes.
Thank you. Please be seated. Ameren?
Mr. Michaels, did you cause to be prepared for filing in this docket direct testimony that has both a confidential and a public version, sir, rebuttal testimony, but also with confidential and public, and sir, rebuttal testimony?
Yes.
Do you have any corrections to that testimony?
No.
If I were to pose the questions that are in that testimony to you today, would your answers be the same today?
Yes.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
With that, Your Honor, Mr. Michaels is actually back on issue 5, so I won't move any of these in at this time, but I will tender the witness for cross.
Thank you, Mr. Lowry. Any cross-examination from the commission staff?
Yes, hopefully very brief. Historically, does peak load for Ameren, Missouri occur in the summer?
Historically, yes.
If I can approach the witness.
You may.
Matthew Michaels, Michels. Yes.
I don't know what this is from.
And can we mark this as exhibit, I think we're at 118?
Yes.
Have you had a chance to review the document I provided you?
Yes.
Do you recognize this as the capacity position work paper from Ameren's 2020 IRP?
I recognize it as a capacity position work paper, although I'm not sure which one.
And work papers like this are usually provided with the IRPs, correct?
That's correct.
Do you see that there's a listing of the plans on that first page of the work paper?
Yes.
And is Plan 19 one of the plans that contemplates Rush Island being retired?
Yes.
And what year is that contemplating retirement in?
2024.
And then if you can turn the page, and I apologize for, you know, making you have to read this, but can you see a required capacity row under Part D?
I'm not sure that I can.
Should be the,
I do see the line.
okay. Can you, if you go to the years 2020 through 2040, what's the lowest number in that row?
You said through 2040?
Yes.
If I'm reading it correctly, it's 7,339,
And what year was that occurring in?
2040.
Okay. And would those values represent Ameren, Missouri's best expectations at the time of the 2020 IRP for its load and planning margins?
Yes.
At this time, I'd like to go ahead and enter Exhibit 118 into the record.
Any objections to admitting Exhibit 118, the IRP capacity work paper?
No objection.
I hear no objections. Exhibit 118 is admitted onto the hearing record.
If I can approach one last time.
Please go ahead. And if we could mark this as Exhibit 119. Okay, would you identify it for me?
It is the reliability requirements. It's probably the easiest title.
Thank you.
Have you had a chance to look over Exhibit 119?
Yes.
And is this a work paper that supports the values that you have in Table 2 of page 19 on your Surrey rebuttal testimony?
That's correct.
At this time, staff would like to move for this work paper to be entered into the record.
Any objections to admitting Exhibit 1 and 19, the reliability requirements, onto the hearing record? I hear none. Exhibit 119 is admitted onto the hearing record.
That's all I have. Thank you very much.
Thank you. Any cross-examination by the Office of the Public Counsel?
Just briefly, Mr. Michaels, do you know what it would have cost approximately for Ameren, Missouri to have installed scrubbers at Rush Island, both units, in about 2010?
We included some assumptions for that in the analysis that I did for my SIR rebuttal testimony. Might be best if I refresh my memory before I answer.
Certainly.
So for the base analysis that I did, which assumed installation in 2012, I used $954 million.
What are you referring to for that?
I'm looking at page 40 of my SIR rebuttal testimony, line 11.
Thank you. No further questions at this time.
Before I ask if there are any commission questions, can the parties provide me with a little bit of clarity in regard to the issue? And it says, were Ameren's, Missouri's decisions regarding whether to continue to operate Rush Island instead of retiring or retrofitting it with glass desulfurization equipment reasonable and prudent? Is this more of a general question regarding these retirement questions, or is this a specific point in time, like in 2021 when it made that decision?
Judge, I think that came from public counsel, and prudency is an ongoing activity. It's not a point in time, although
But you would agree that decisions are generally a point in time. There is a point at which a decision is made.
yes, but I'm saying that it's a continuum of decisions.
Fair enough, proceed. All right, are there any commission questions? Chair Hahn, please go ahead.
Thank you, Judge. Good afternoon.
Good afternoon.
After reviewing your testimony, I just had a few questions. One is because I'm not a technical person. I'm hoping you can explain some calculations to me. In your testimony, you note that the long-run cost to customers in the present value of revenue requirement is noted as PVRR. Can you further explain PVRR and how it's calculated?
Sure. So what we look at is for a particular option or portfolio, all of the costs that would be included in the revenue requirement used to calculate customer rates. And so we look at those for each year of a period, say 30 years, and then we use the weighted average cost of capital to discount those back to today's dollars or another year's dollars.
Thank you. The question is, I thought I understood the question before us in 3B before I got the response of the continuum from public counsel, but I'm going to approach this issue as also making it a company approaching this decision at a point in time, and because I think that's what the statute requires. So I'm going to ask you some questions kind of relating to your testimony as far as retrofit or retire.
Okay.
You do some analysis of your 2020 IRP, and you also note in your testimony how that has changed. But first, I was hoping you could talk me through your 2020 IRP and the assumptions you made at that time. So if you wouldn't mind recapping that from your testimony.
Sure. Chair Hahn, you're talking about the retirement versus retrofit analysis based on the 2020 IRP?
Yes,
Is that
thank
correct?
you.
Okay. So that reflected obviously all of the assumptions that we had included in our 2020 IRP. So things like natural gas prices, carbon prices, coal prices, costs for different resource types, wind, solar, et cetera. And then we looked at, a case where we retire the unit in 2024, or the units. And for that, we just simply cease operating the plant, so no going forward cost impacts. And then in the other case, we assumed that we retrofit it with the scrubber technology, also in 2024. And so that includes the cost of the scrubber and then the continued operation and maintenance expense through 2039, which was the previously determined retirement date. And so we're capturing then all of the costs and market revenue impacts of those two different cases for comparison to say, okay, this is going to be the impact on customers year by year, and then present valuing that back to today to see what's the overall impact on customers over that time.
From my recollection, the PVRR in your analysis was higher in 3 of the 48 combinations for scrubbers versus retiring the asset. So according to your economics, it was more economical to retire the plant based upon your analysis. Is that
That's correct.
How recently did you conduct that analysis was that just in 2020, or have you repeated that analysis since that time?
Yes, so I did repeat the analysis using assumptions from our recently filed 2023 IRP, and I included the results of that in my rebuttal testimony.
Can you talk about some of the changes since the 2020 IRP, specifically as it relates to MISO with resource adequacy concerns? Certainly, I noted in your testimony they're significantly different now than they were then. Can you talk a little bit about that?
Sure. So when we did the 2020 IRP, the resource adequacy construct in MISO was focused on summer peak. And so they would do a study every year, an LOLE study or loss of load expectation study, to determine what the planning reserve margin requirement would be that would be applied then to the company's summer peak load for determining what the resource need was. In 2021, MISO applied to FERC, I think it was November 2021, to change to a seasonal construct, seeing that there was more of an appetite for looking at reliability season by season, in part because there were different impacts on different kinds of units across the year, particularly on gas-fired units and the availability of fuel during the winter. And so they applied to FERC for that. They did provide some very preliminary figures as to what that would look like for our system in terms of the unit accreditations or how much capacity we would expect to get from units during the different seasons. And so, that's something that we looked at the time we made the decision. Subsequent to that, we spent more time and put in a good deal of effort to try and estimate what that construct would look like going out into the future, because we had to update our preferred resource plan following the decision to retire Rush Island. So we included that in our updated preferred plan that we filed in 2022. Then FERC approved MISO's seasonal resource adequacy construct in August of that year. So this was after the decision, after the plan was updated. And only at the end of that year did we get really solid numbers from MISO with respect to unit accreditations, what the planning reserve margin requirement was going to be, all by the 4 different seasons to use then in our 2023 IRP. And I included a table, which you've probably seen, that lays out how some of those things changed.
I see a figure 5 on page 18 of your rebuttal testimony. Is that what you're referring to? Or a chart? not a
No,
table?
I'm thinking of a table that indicates what the changes to our long-term expected capacity need would be. Just give me a moment, I'll find it. Maybe it's earlier in my testimony than I thought it was. It's Table 1 on page 17. We were only a page off and I missed it. So, you know, this table kind of summarizes the changes that happened between when we filed our notice of change of preferred plan in 2022 and what we ultimately included in our 2023 IRP based on the good information that we finally got at the end of 2022 from MISO. Most of the changes are related to changes in unit accreditation, changes in the winter planning reserve margin, which went way up, and then also a change in the way that we did our peak load forecasting for winter.
And you noted at the bottom of that page that the company expects to be in a net short position during the years 2025 to 2027. Can you describe to me the action, if the commission were to move forward with securitizing this plant as requested by the company, how do you anticipate to make up the net short position over that time frame?
So, you know, since we're in MISO, we have the ability to purchase capacity from other entities within MISO. We've historically used what we've called a build threshold of 300 megawatts that says until you're 300 megawatts short, we won't assume that we're adding any resources to meet that. So in these instances, all of these shortfalls are below that threshold. So historically, we would not plan to build for that. In the intervening time, we have seen, you know, some of the severe weather events that have become more common. And so it appears that there's a need for even greater resource capacity in order to meet those needs above and beyond what MISO suggests through its resource adequacy process. And so we have been adding capability to simple cycle combustion turbine units to be able to use oil fuel in the winter whenever there's no gas available. We've done that at a couple of different sites. We're also planning to do that at another one of our sites at Audrain. And then another important thing for meeting those resource requirements is the continuation of our energy efficiency and demand response programs under MIA. So all of those kind of work together along with the renewable resources that we're planning to add, which provide mostly energy but do provide some capacity benefit as well. All of those work together to help meet those customer needs in the short term and the long term.
I hear a lot here in the capital city about economic development projects and the need for additional capacity to bring projects to our state. And not any projects that can provide, that are dispatchable. And so can you speak to adding specific resources in place, or how would retiring Rush Island potentially impact the ability to be a competitor for economic development projects?
So I don't know how retirement of Rush Island would affect things. Certainly, if we had the capacity, we would have perhaps more ability to meet some of those needs, at least for a short term, until, you know, unless and until there was a major expense that did flow out of some of the regulations that might be considered in the future. So, you know, that might stretch things a little bit. Am I understanding your question correctly?
Do you, in your forecast, I'm sure you do, take into account anticipated low growth as a result of economic development projects?
We do, although it's become increasingly a challenge to estimate where that's going to go with some of the things that we're seeing across the country with respect to data centers and other such loads.
Can you give me an example of average economic development project size from 2020 to current? I can think of the utility on the west side and how that has changed, but I'm wondering if you can provide the same.
Yeah, and this is something that has kind of evolved in the last year, I would say. But, you know, just a couple or 3 years ago, we were looking at average economic development project sizes probably in the tens of megawatts. Now we're looking at potential projects in the hundreds of megawatts to even a gigawatt or more range.
Can you speak to Rush Island's operation, for example, planned outages, scheduled outages, how much it's actually producing for MISO currently, and maybe what its operational pattern has been over the last year or two?
Sure. It's been very limited. Since September of 2022, we've been operating under what's called an SSR agreement, or System Support Resource Agreement with MISO. There are some very specific and very complicated triggers for that that I'm not intimately familiar with, but they include looking at things like whether other units in the region are in operation. They also look at temperature triggers to determine whether Rush Island will operate. And as a result, Rush Island has operated far below what its historical production has been the last few years.
Okay, can you give me any, hard data or, examples of how it had been operating versus how in
Sure.
the past 2 years it?
Sure. Annual production from Rush Island previously was 8 or 9 million megawatt hours a year. That's for both units together. And now it's 1 million megawatt hours or less per year operating under the SSR agreement.
That's really helpful, so, thank you. Let's see if I have any more questions. I don't have any.
Okay.
Thank you.
Any further commission questions? Commissioner Holzman, please go ahead.
Thank you. Good afternoon.
Afternoon.
You said that MISO, on their capacity projections, that if you're under 300 megawatts, you're going to buy it from somebody else and not trigger a requirement to build. That accurate?
That's accurate.
What capacity do you see in terms of demand response? Like how much, if you were an aggressive demand response, what kind of, how many megawatts do you think could be generated in savings from that effort?
Yeah, I believe our latest potential study put that in the 400 to 500 megawatt range.
Okay, so fairly significant.
Yes.
What about, same question with distributed energy resources? How much capacity do you think you could gain with an aggressive distributed resource campaign?
So we do include some assumptions in our load forecasting with respect to distributed energy resources, and I believe the middle scenario has us getting to something like 600 megawatts by 2040. And then on top of that, in the same demand side potential study where we look at energy efficiency and demand response, they also look at some distributed energy resource potential as part of a program. To date, that potential has come in very small relative to the other programs.
Okay, but if this plant is has a natural life of 2039, then by that date you could potentially see a gigawatt in savings / production from demand response and distributed energy.
Certainly.
Potentially. Okay. You heard me talk a little bit earlier with Mr. Majors about the retired asset value.
Yes.
My first question is that figured into the amount you're trying to securitize? Have you already placed a value on either scrapping or repurposing any of the existing assets?
Generally, for assets of an age similar to Rush Island, we assume that the scrap value is on the same order as the cost of dismantling. So roughly no net benefit from that.
Okay. What about the site itself? Do you have any value attached to what you'll do with this? Do you have a plan for what you're going to do with the site in the future?
Yeah, in our 2023 IRP, we talk about the potential for locating storage resources at the site, battery storage resources.
You have a capacity on what you could potentially do there?
I'd say potentially 200 megawatts. I don't know if we could fit 400 there, but it's a couple hundred megawatts.
A couple hundred megawatts. And
Yeah.
so So essentially, and what kind of time frame are we talking about? How long would it take to transition from, what's there today to storage being dispatchable?
Yeah, I don't know that level of detail. I can tell you that our 2023 IRP preferred plan includes battery storage in 2029.
2029, okay.
Yes.
So essentially, within 5 years, if you added 200 megawatts of storage there, you could potentially firm up either a wind asset or a solar asset and make that more baseload distributable.
Certainly, and we've included the storage assets, the demand response resources in our IRP preferred plan right alongside the wind and solar additions that we're reflecting.
Do we know how MISO would count that in terms of capacity for your requirement?
The battery storage?
Yeah.
Right now, we're assuming a capacity credit, I believe, of 95% of the rated output. So a
Okay.
200 megawatt battery would be 190 megawatts of capacity credit.
Would that delta out from the generation source, or would it be in addition to? Like, let's say you say you were having wind, and the wind was 200 megawatts. Would then you net out that, or would it be in addition to that nameplate capacity?
It could potentially be additive at a given moment in time.
Right.
Where you may have stored some solar energy during a time, and then you're releasing from the battery at the same time the solar is generating. That's a possibility.
Okay. And my last question is, we talked earlier just about from a macro perspective. I just want to hear for the record, it's your testimony that it is in the best interest of the ratepayers to decommission this and retire this coal plant, securitize the amount that would otherwise be depreciable, and that is a more prudent measure than if you were to spend the money on the environmental upgrades and operate it for another 15 years.
That's correct.
All right, thank you. Thank you, Judge.
Thank you, Commissioner Holzman. Are there any other commission questions? I hear none. At this point, I'm going to ask if there's any recross. I'm also, Mr. Kaufman, I just noticed you're here from AARP and Consumer Council of Missouri. Did you have any cross-examination or recross?
I do not, Your Honor. No questions.
Any recross from the commission staff based upon questions from the commission?
A few. Do you recall talking with Chair Hahn about NPVRR?
Yes.
Does NPVRR assume perfect rate making?
I don't know that it assumes any rate making. It's the revenue requirement. How it's recovered, I think, is another matter.
But if you don't build in the rate cases where items are collected or returned to customers, can that impact how that that NPVRR figure would work?
I think what you'd end up with instead of revenue requirement is present value of revenue.
Are you aware that MISO, do you recall discussing the seasonal construct? Were you aware that MISO began discussing the seasonal contract prior to 2020?
Yes.
And is it your understanding that the 2020 filing was actually proof of concept, which was the culmination of previous discussions?
Which filing?
The 2020 announcement, or 2021, I'm so sorry, 2021.
Can I ask you to repeat the full question and give me the context?
So the 2021 discussions, do you recall that they were kicked off by the 2020 proof of concept filing?
Yes.
Okay. You also had discussion with the bench about the IRP and triggers for build thresholds. Do you recall that?
Yes.
Before the 2023 IRP, when was the last IRP that Ameren was close to the build threshold on?
Well, it might be helpful to explain what the build threshold is. It's a trigger that we use for adding resources in the different alternative plans that we evaluated as part of an IRP analysis. So it's used to develop alternative resource plans. I'm not sure that you would say we're close to it or not.
Okay, thank you for that clarification. You had a discussion with the bench about how many hours Rush Island was operating prior to the, oh God, I'm not going to think of the acronym, this like SSR, and before. Do you recall that?
Yes.
Do you know how many hours Rush Island was operating before the 2007 project?
No, I don't.
Okay, I have no further questions then. Thank you.
Any requests from public counsel?
Yes, thank you. Mr. Michaels, do you recall in one of your responses, you talked about converting some units to burn oil as well as natural gas?
Yes, although it's not a conversion, it's an addition.
Well, it changes the capability of the unit for what fuels it can burn, correct?
Correct. We're adding the capability to fire with oil on units that can and will continue to burn gas.
And when did you start doing that conversion to be able to burn oil as well as gas?
I'm trying to recall. I think it was 2022.
And how many megawatts of capacity are we talking about for the units that have been converted?
Oh,
And if you want to go by unit, that's fine.
yeah, I don't know that I can recall specifics, but I'll say total of a couple hundred megawatts.
And what kind of sizes are these units if the total's 200 megawatts?
So
Roughly.
this is an addition of capacity in the winter specifically because that's when the oil firing helps with the capacity. So it's not the full capacity of the units. It's just allowing us to run them at other times when we might not be able to run them on gas. So these are the units at Kinmundy and Pinot Creek. And I don't recall right now. I guess I've got a capacity chart in front of me, don't I? If I can read it. So for Pinckneyville, we're showing total capacity on this chart of 316 megawatts, although I'm not sure what season that I'm looking at here. I guess this was 2020, so it would be summer. So that was 316, and then Kinmundy is 438. Those are summer ratings from this chart.
So it's Kinmundy and you said Pinckneyville?
I'm sorry.
Oh, I thought it was
I
Pinot
erred.
Creek.
It was Pinot Creek, you're right. Pinot Creek is 192.
So it's more like a little over 600 megawatts?
What's a little over 600 megawatts?
The total, 438 and 192. And I understand it's a
Yeah.
capability in winter as opposed to, roughly.
Right, yeah, so summer between the two, I think you probably did the math right, 600 sounds right,
Roughly.
sure.
Where is Pinot Creek located?
It's in Missouri,
And Kinmundy?
it's in Illinois.
Is Illinois implementing a restriction on CO2 emissions?
Yes, through CEJA.
When is that to take effect?
It already has taken effect.
So how does that impact the Kinmundy plant then?
It does restrict its hours. The addition of the oil-fired capability there was relatively inexpensive, I think a couple $1 million. So adding that capability improves the value in the winter season when we might run into things like another Winter Storm Elliott, for instance.
Do you know what impact adding a battery at Rush Island would have on local property taxes, revenues?
No, I don't.
No further questions, thank you.
I believe Chair Hahn has a few more questions.
In your testimony, you talk at length about the 2020 IRP, and in summary, you also then say, well, you know, I'm summarizing here. Staff didn't raise any serious concerns with the IRP at the time. Is that a fair statement?
That's fair.
Staff now and Ameren may have some capacity issues from the numbers, but we may not know the outcome of those, you know, capacity shortfalls during the pendency of this case. You know, the lights may never go out. Is it your position that the commission would have to make a decision on the economics of the case, retrofit or retire? And that was the prudence, making a decision on prudency based upon that, and then not us just not knowing the harm of the potential capacity shortfalls moving forward.
Yeah, I'm not an attorney, of course, but my understanding is that the securitization statute requires that the decision to retire be prudent, but doesn't address any decisions that might have led to that.
Yeah. No further questions.
Mr. Kaufman,
No questions, Your Honor.
Commission staff? Public counsel?
Briefly, following up on what Chair Hahn just asked you about, couldn't Ameren, Missouri didn't Ameren, Missouri make decisions about whether or not to put on scrubbers, at least starting from the point whenever the EPA began its enforcement action at Rush Island?
I'm trying to think of how to frame your question in my mind. So you're asking me, were we, I guess continuously, in effect, we were deciding not to put scrubbers on because we weren't deciding to put scrubbers on.
Thank you.
Any Ameren redirect as to either round of commission questions and recross?
Yes, Your Honor, thank you. I'm probably going to jump around to here a little bit, Mr. Michaels, because the questioning sort of jumped around, but I will start with Mr. Williams' last question. You said that Ameren, Missouri, of course, was deciding not to put on scrubbers. You know, when it didn't decide to put them on, it was deciding not to put them on, I think was the basic point, right?
Right.
In making those decisions, which I assume would have taken place just as a part of resource planning on sort of an ongoing basis, certainly a periodic basis, right?
Sure.
Am I correct to assume that analyses were being done of the of two things? Let me break it down. Analyses were being done of the environmental requirements that existed, right?
Correct.
And analyses were being done of various alternatives for complying with those environmental requirements, right?
Correct.
And is it true that, again, at least on a periodic basis, every 3 years, maybe more often, the company actually analyzed the impact on customers of spending the money on scrubbers and O&M on scrubbers, et cetera, versus complying in an alternative way?
I don't know that we were always looking at scrubbers specifically as an option simply because that may not have been required by the regulations that we were evaluating. But to the extent it did, yes, there would have been economic analysis saying this, weighing this option, for instance, against low sulfur coal.
If an environmental regulation existed and scrubbers were a potential way to comply with it, is it correct or incorrect that the company would have been analyzing, should we comply with it by spending money on scrubbers, or should we comply with it in another fashion?
Definitely.
The chair asked you some questions here toward the end about Ameren, Missouri's position on the need to decide sort of the economics of the retrofit versus retire decision. Do you remember that?
Yes.
You've prepared two analyses that are in your testimonies in this case of that question, right?
Yes. Of the decision to retire in 2024, and then also the decision not to scrub in 2012.
Well, the last one you mentioned is a different analysis about, what would have happened in an alternative universe if the company had made a different decision on the NSR permits and then scrubbed the plant back then. But you've also looked at what did the economics tell Ameren, Missouri about whether it should retrofit or retire once it lost the district court case in August of 2021. You looked at that back in 2021, and you looked at it again recently and filed analyses in this case, right?
Correct. And most recently, what we found was that we would save upwards of $1 billion. I think there was one case that was slightly below $1 billion benefit from retiring rather than retrofitting with scrubbers, but most of the cases were over $1 billion.
So when you actually you made the decision in December of 2021, and you had one analysis then that said in 45 of 48 cases, retiring was better for customers, right?
Correct.
But when you looked at it again under essentially current conditions, what we know now about the MISO seasonal construct and other things that have happened, the conclusion became even more clear. Is that fair to say?
Yeah, that's fair.
Does that suggest, obviously with Rush Island off the system, that capacity is not available anymore, right?
Yeah, it soon won't be.
And if there's a need for capacity going forward, Rush Island can't provide it, so something will have to, right?
Correct.
What does the fact that the net present value of revenue requirement is shown to be much lower in the retire case versus the retrofit case, what, if anything, does that tell you about the more economic source of the capacity that the company would need in the future? Is it Rush Island or is it something else?
It's something else, and specifically it's mostly gas-fired resources along with energy efficiency, demand response, and renewable resources.
Is that principally because the only way to keep Rush Island open would be to spend hundreds of millions of dollars or whatever it ends up being on scrubbers, and that would impact the price of that capacity?
That would
right?
be the only way, and absolutely it would.
You were asked questions by Mr. Williams about the addition of oil burning capability in the winter to certain units. Remember that?
Yes.
And you looked at a capacity, you looked at I guess it's an accreditation chart. I guess that came out of Exhibit 118. Is that right?
Yes.
And you said those were summer ratings?
Correct.
Are the winter ratings, and I know you probably don't remember what they were at this time, and they could be different now, right? This is 2020, the accreditation changes. But are the winter ratings different than the summer ratings?
They are. They're
Higher or
generally lower.
Generally lower. Okay. Ms. Mers asked you some questions based on Chair Hahn's questions about net present value revenue requirement analyses. Do you remember that?
Yes.
And a question about perfect rate making. Do you remember that?
Yes.
And you said it doesn't assume any rate making at all. You remember that?
Correct.
Can you elaborate? Can you just explain, maybe in layperson's terms,
Sure.
why it doesn't and why that makes sense that it doesn't?
Sure. So when we're comparing options, which might be, limited in this instance, like to scrubbing Rush Island versus continuing to operate it, or an entire portfolio, which would also be implicated by that same analysis. What we're looking for is the long-run cost that the utility would seek to recover from customers through rates. And so the revenue requirement itself is that cost. What happens with rates in the intervening time is going to be a matter of individual rate proceedings and allowed returns, et cetera, et cetera. And so what we're really after is what's the long-run cost to customers of these different options. The integrated resource planning rules the commission adopted most recently in 2011 specifies that net present value revenue requirements are to be the primary criterion for selecting a resource plan. We've been using that all along with some other criteria, but NPVRR is the primary one. And so that really, to me, is the best way to assess the cost differentials between two different options, because there's going to be different timing, there's going to be resource differences, all of those things, and to try to capture what the appropriate rate-making treatment is going to be in advance for a 20-year plan is sort of a fool's errand.
Well, and as you indicated, the commission's IRP rules are telling you not to do that, isn't that right?
That's correct.
What you're trying to do is you're trying to make the best decision for something that's probably going to be around for 30 or 40 or 50 years. And, if you pick gas plant versus a coal plant, there's going to be rate making different. I mean, presumably if you put them at the same time, the rate making treatment's going to be probably the same as you go forward, but you're taking that variable out, right, basically?
That's right.
You were asked questions by Ms. Mers about MISO discussing, I guess, having some kind of proof of concept paper or announcement or something in 2020 about the seasonal construct, right?
Yes.
Did the proof of concept, whatever it was, did it provide the company with unit accreditation values or planning reserve margins or any figures that would actually allow it to figure out what its capacity position would be in the various seasons?
No, we only got very preliminary information until the end of 2022, prior to the 2023-24 planning resource auction.
Now, if I remember correctly, the seasonal construct was not assumed to be in place when you did the 2020, the December 2021 retire versus retrofit analysis. Is that right?
Could you repeat the question, please?
Was the seasonal, was the conceptual seasonal construct that MISO was talking about in late 2021, was that accounted for in the December 2021 retirement versus retrofit analysis?
In the analysis itself proper, no, but it is something that we looked at the time, given the very preliminary information that we had gotten from MISO, which is on this other schedule.
And when you looked at it, I guess you must have looked at it conceptually mostly because you didn't actually have a construct in place. When you looked at it conceptually, did it suggest that it would have changed your decision?
No, it didn't. And something in particular about these numbers. When MISO was thinking about this concept in 2020 and 2021, they were drastically changing the way unit accreditations were calculated, and along with that, drastically changing the way planning reserve margin requirements were calculated. And based on information and conversations with MISO at the time in 2021, say August, September timeframe, our understanding was that because of the way that they were planning to do the unit accreditations, that there would be little or no planning reserve margin requirement added to the load.
Did you have any information did you have information at that time that was suggesting to you that if Rush Island was retired in 2024, that the company was going to be in a capacity shortage position starting in 2025?
Yeah, that's the table in my testimony that's supported by the exhibit that was distributed, and that showed that, let me put the glasses back on. That showed that in none of the 4 seasons would we see a shortfall.
If I'm looking at Exhibit 118 and I look at, this is hard to read, but I think I can make it out, 2025, and I look at the capacity position row down there toward the bottom of that page, are you seeing what I'm seeing?
Is it capacity balance?
Capacity position after all adjustments, is that the right one to be looking at? Or am I should be looking, or what does, let me ask this way, does this Exhibit 118 tell you what the predicted capacity position of the plan that you looked at in the 2020 IRP that had Rush Island going away in 2024? Does this Exhibit 118 tell you what the expected capacity position was in 2025 and so on?
Yes.
And what should we be looking at to find that?
It would be the, if I'm looking at the right one, the capacity, well, no, that's not right.
Is it the capacity
I-
position after res compliance row?
This is really hard to read.
Your Honor, if I can approach, maybe get an exhibit marked,
I see it now,
can you
yes,
see it?
yes.
So you remember my last question?
Could you repeat it?
Should we be looking at the capacity position after res compliance row?
I believe so, yes.
And what was the, with Rush Island gone in 2024, according to the planning done in the 2020 IRP, what was the expected capacity position?
In 2025, after
Yep.
it's gone,
Yep.
looks like positive 561 megawatts, so excess capacity.
And then that stays sort of flat and grows a little, and it's up to about 1,000 megawatts by 2029, 2030, right?
That's right.
Now, you didn't explicitly, as I recall, you didn't explicitly take the seasonal construct into account, although you said you considered it when you did the December 2021 retirement versus retrofit analysis. But you did attempt to take it into account explicitly when you, when the company filed the change in preferred resource plan in June 2022.
That's correct.
And when you did that, and that of course assumed a Rush Island retirement in 2024.
That's right.
When you did that planning analysis suggest a shortage of capacity in 2025?
I don't believe it did, and I think there's a figure in my rebuttal testimony that shows that. Yes, it's figure 4 on page 16 of my rebuttal testimony, and it showed a capacity excess of, I believe that says 24 megawatts.
And there might have been, if I recall, there might have been some small capacity shortages in a couple years after that. Is that right?
That's correct. Nothing beyond the 300 megawatt build threshold.
And you talked about that, I think, with the chair as well, or with somebody. And if you're, am I correct to understand if you don't see a capacity need that's beyond the build threshold, what that's telling you is you wouldn't do anything different about capacity in your planning, right?
That's correct. For meeting the resource adequacy standard of MISO, that's correct.
The chair asked you some questions about economic development projects. You recall that?
Yes.
We talked a minute ago about what your analysis is suggesting, and that is your retire versus retrofit analysis in terms of what would be the most economic, what capacity would be most economic to serve such load? Would it be Rush Island or would it be something else? And you said it would be something else because you'd have to scrub Rush Island, and right? Is that right?
That's right.
Is that also true about these economic development projects that may come along?
It's true for any loads that we would see.
What's cheapest to serve is sort of agnostic to what the load is?
Yes.
Do you remember when the company lost the NSR case, once and for all?
Yes. It was, I think the decision came out in August of 2021, as I recall.
And absent a change to the order, what obligation was the company under once that order became final?
We would have to pursue the remedy, which was to build a scrubber at Rush Island. I don't remember exactly how long we were given to do that. I believe it was about 4.5 years.
So, till 2025 or perhaps,
Yeah, early to mid 2025, I believe.
do you have an opinion about how long it would take to,
Let me correct that. I think it was 2026.
do you have an opinion about how long it would take to build a scrubber?
It would take about that long, is my understanding.
And the company the company was under order to build it, didn't end up building it. Does that mean that the company had to ask the judge's permission to make a different decision?
Yes.
Could the company have waited 2 or 3 or 4 years to ask the judge to do that, given that it was going to take that long to build it and it only had that long to build it?
I don't see how that could have been done.
Those are all the questions I have. Thank you, Your Honor.
Mr. Mitchells, you may step down.
Thank you.
I believe the next witness is staff's.
Staff calls Ms. Eubanks back to the stand.
Ms. Eubanks, I'll remind you you're still under oath.
I think we can go ahead and tender Ms. Eubanks for cross then.
Any cross-examination by the Office of the Public Counsel?
No, thank you.
Any cross-examination on the 3B issue by Ameren, Missouri?
Yes, Your Honor, just a little bit, I think. Good afternoon, Ms. Eubanks. How are you today?
I'm good. A little warm.
It is a little warm in here. You discussed some transmission upgrade projects at page 23 of your rebuttal testimony, do you not?
Let me get there.
As a matter of housekeeping, it is a little warm in here, and I'm not going to require anyone to wear a jacket who doesn't want to, if it would be easier.
Appreciate it. So yes, I talk about the Rush Island reliability projects in my testimony.
Which are transmission upgrade projects that are necessary because Rush Island's retiring to keep the grid reliable, essentially, right?
They are related to the Rush Island project or retirement, and they are transmission projects, yes.
Those costs have not been included or even sought for inclusion in a revenue requirement in an Ameren, Missouri rate case, correct?
That's correct.
Once they are done, presumably Ameren, Missouri will file a rate case, and if they fall within the test period and the true-up period, Ameren, Missouri will then include them in its rate base and ask that its rates be set to reflect those costs. You would expect that, right?
I would.
That hasn't happened yet.
It has not happened yet.
And when that happens, assuming it does, the commission will have the opportunity to review the projects and their costs in that future case, right?
That's correct.
And you even agree that it would be appropriate for the commission to decide questions about those transmission projects in a future case, right? In a future rate case.
Yes, I do.
You also agree that those costs are not included in the energy transition cost or any other cost that the company seeks to securitize in this case, right?
Ameren, Missouri has not sought to include that in the securitization case. That's correct.
Which means whatever those costs end up being, they won't or can't affect the amount of the securitization bonds Ameren, Missouri is asking to issue, can they?
I don't know whether they can or not, but it was not proposed by Ameren, Missouri to be included.
You also discuss in your testimony the possibility of future capacity costs that Ameren, Missouri might incur under your hypothesis because Rush Island's no longer around, right?
In the short term, yes.
No evidence is presented in this case that establishes that Ameren, Missouri customers to date have actually incurred any higher rates based upon a claim about capacity that it might have to buy in the future, has it?
Right, so the figures I provided in my testimony are estimated values that are potential future harm from my view.
But obviously, potential future harm, potential future capacity costs haven't been reflected in rates to date, have they?
I agree.
With respect to any mitigation remedies that arise out of the district court case, the federal district court case, there's been quite a bit of discussion about mitigation remedies in this case, right? You remember that?
We've talked about the potential for future remedy from the NSR litigation, yes.
It's also true that there's no evidence in this case that customer rates have to date been impacted by any future remedies out of the district court. Isn't that right?
Evidence in this case, I'm not aware of there being an impact to current rates based on the NSR litigation.
I mean, it's impossible for there to have been any impact on current rates since Judge Sipple hasn't actually ordered any future remedies yet, right?
Yes, the future remedies are future. I think I was clear in my rebuttal testimony about that.
You have agreed with me previously that the question of whether something is well documented is different than the question of whether the decision itself was a good or bad decision. Isn't that fair?
I think documentation goes to the question of reasonableness, but I do recall that question from my deposition.
And you agreed with me that they are different, are they not?
Yes, I do think they are different questions.
Had Ameren, Missouri made a different decision on the NSR permits, and then the plant got scrubbed and it's not retiring, the plant might not have lived to 2039, isn't that right?
It's possible.
You're aware, for example, that there's a good neighbor rule that's been proposed by EPA,
I am aware of that, yes.
and there's a separate greenhouse gas rule that's been proposed by EPA.
I am aware of that, yes.
And I'm not asking you to agree that those rules would or would not have led to an economic decision later to retire Rush Island, but there certainly exists a risk that those proposed regulations or some other environmental regulation could, before 2039, put Ameren, Missouri, or other utilities for that matter, in the position of having to decide should I spend a lot of money to comply with those regulations, or should I retire instead, right?
So I think in Ameren, Missouri's motion to modify their remedy ruling, they mentioned 4 things that were changing from the 2019 remedy order. And that was natural gas prices were increasing, carbon price assumptions, social and environmental justice, governance kind of policies, and of course the securitization statute. So those are the 4 things that Ameren, Missouri told the court kind of changed that led to their decision in 2021. So to the extent that Ameren, Missouri considered those, you know, I will say the 2020 IRP is really, you know, that decision is, I think, my understanding is based on a difference between the 2017 IRP and the 2020 IRP more so than the retrofit retirement analysis Mr. Michaels performed.
Okay, thank you. Those are all the questions I have.
Any commission questions? I hear none. In your rebuttal testimony, you list 3 concerns that staff has.
Yes.
And those would be the DOJ, Department of Justice, is seeking additional remedies other than just the retirement of Rush Island. And I believe that you had also thrown out some DOJ numbers, but that would be related to a remedy numbers that the Department of Justice might request of the judge, correct?
That is my understanding, is those numbers reflect what the DOJ has requested. I think that my understanding from reading the transcript, and then also I asked in a data request for, you know, Ameren, Missouri's motion. Well, there were some kind of pleadings made in the case that I had asked for. And so, yes, my understanding is the parties are kind of instructed to, or were instructed to come to some sort of resolution or make a proposal that would kind of be acceptable to all. And I mean, it doesn't sound like they're there yet, so.
Yeah, and they may never get there, correct?
Sure,
It may end up with the judge just picking a number.
that's right.
And at this time, you have no idea what that number is going to be. Is that correct?
That's right. The 275 million is just based off of what's in that transcript.
So that both hasn't occurred yet and is non-quantifiable at this point.
I agree with that, yes.
Now, your second concern is Ameren, Missouri's 2023 IRP suggests that it will be short on capacity for MISO resource adequacy purposes. Is that correct?
That's correct.
But again, that's in the future, correct?
So it is in the future, but staff's position in this case, my position, is Ameren, Missouri, and you heard Mr. Michaels talk about it, they understood that the seasonal construct was changing when they made the decision to retire Rush Island. So we're bringing it up because we know a little bit about that decision-making, and that they had some understanding that that seasonal construct was changing. And it is a future potential harm that may arise or may not.
So at this point, no harm has occurred.
That's correct.
And is that quantifiable yet?
It's estimated, but no, it's not. I mean, it's estimated. Those are the values that I provided in my testimony.
And the third concern is the Rush Island Reliability Project that's not securitized. Is that correct?
That's
or that they're
correct.
not asking.
They're not asking to securitize it in this case, correct?
And what's the potential harm there?
So from my perspective, Mr. Michaels did an analysis in his direct testimony. He based it on some break-even costs, and he did some scenarios about what the expectation for how Rush Island would be operating as an SSR. Because when that analysis was done in 2021, it was before Ameren had made the retirement decision and before MISO kind of indicated that Rush Island would potentially need to be classified as an SSR, which, I think there was some discussion in opening statements about why staff opened its investigatory docket. And it was related to the SSR designation, not related to the retirement decision. I wanted to make that pretty clear. Sorry, I maybe lost track of your question in my answering.
I was asking you to explain the harm as it might occur.
Sure. So at the time of my rebuttal testimony, I was looking at what Mr. Michaels provided in his direct testimony, which was based on that 2021 analysis. I think as we've talked about, there's a couple scenarios where the retrofit decision is maybe looks a little bit more favorable in the 2020 scenario, right? Or 2021 analysis. And he did some looks at the transmission break-even analysis and those scenarios about what was expected from potential operation of Rush Island in the short term as an SSR. And, obviously, we also knew that there was potential future remedies from the court that we don't know, not included into his break-even analysis. And then we knew that the seasonal construct was changing and wasn't taken into account. So when you look at all of those, I think it calls into question, that break-even analysis and whether, the increase of costs that we saw in the transmission projects from what we previously knew them to be. I think all of that in culmination is really what that's about.
And as of this point, that is also not quantifiable, correct?
I think we have a pretty good idea of what the current estimates are, just as clear as some of the costs that are being securitized in this case.
So you believe that one's a little firmer than the others?
I do believe it's a little firmer than the others.
Okay. This, as frequently has been said, is kind of a two-step process. And this question, indeed, the 3B kind of implies that when it, the first question is, was their choice to retire as opposed to install scrubbers prudent? And obviously, if the commission decides that it wasn't, then they don't get to securitize the retirement of Rush Island, right?
That's correct.
And you've indicated that these go into a future proceeding, and I assume it would maybe be a rate case proceeding. But where are we talking about? I mean, how far down the road? At what point does this become quantifiable?
So the reliability projects, I would expect that we would see in the next Ameren rate case, or at the very latest, the next one after that. One single reliability project. I think it's under one project number. Made that clear. And the capacity shortfall, potential capacity shortfall in the short term. I think I highlighted the years 25, 26, 27. So that's a little bit further out. And then obviously the court remedy, no, I don't think anyone can know.
I'd like to kind of go the other scenario for a second.
Sure.
If the commission determines that the decision to close the plant was prudent, what happens to the second part of this analysis then?
You mean the future harm that staff has identified as concerns?
Correct.
So I think what staff's recommendation is that the commission should make a decision on whether the retirement by October 15th, 2025, that's the correct date, is reasonable and prudent. And from my perspective as an engineer, I can't imagine that it would be a good idea to say now, ignore that court order that we do have now. And I understand this is predicated on Ameren, Missouri's decision-making. They made the decision in 2021. They reevaluated things in 2022. They, asked the court for a date certain in August of 2023. To me, the decision on the retirement kind of evolved over that time period. But ultimately, I can't imagine that it would be a good idea now to say, the retirement is not reasonable. And that's my perspective.
And maybe I didn't understand your answer. Maybe I didn't ask the question. It sounded like you said if the commission determines that the retirement was prudent and the harm goes to a future proceeding, then the commission would need to make another prudency decision regarding an October date? Is that?
No, I think the question before the commission now is Ameren, Missouri's decision to retire the Rush Island plant.
I see the disconnect. All right. The disconnect, it's in my question. Okay. If the commission were to determine that the retirement decision over installing the scrubbers was prudent and they were allowed to securitize and this harm goes to some sort of future proceeding, what are we determining on there if the prudency of the plant has already been determined? I mean, what do you do with the harm?
Well, I think staff would argue that ideally the order will be written in a way that staff can argue what it needs to argue in a future case.
Can you clarify that?
Yeah, I mean, I think if you answer the question, is it reasonable and prudent for Ameren, Missouri to retire Rush Island by October 15th, 2024, 2024, is that reasonable and prudent based on the evidence in this case? I think you can answer that question. And I think that preserves concerns about future harm to a future rate case. So obviously I'm not an attorney and you all are much more versed in writing orders, so.
Okay, thank you. Chair Hahn would like to ask a question.
Sure.
Good afternoon, Claire.
Good afternoon.
As we were discussing, prudency is related to this retirement and also capacity issues. You have also in your rebuttal testimony, you talk about the 4 solar CCNs, the 3 that were just granted and the 4th that's conditional. Can you talk about why that's in your rebuttal? It's your rebuttal testimony.
Yeah, the reason is because OPC proposed a disallowance using the solar CCNs as part of their component of their disallowance.
And they help me from your perspective understand their math. It's the cost of the 3 plants minus the scrubber. Talk me through that.
I haven't seen work papers from Mr. Seaver. They may have come in and I just didn't get a chance to look at them. I'm not sure. And I missed some of his corrections to his testimony.
And is that so is OPC arguing, I guess I'm not totally following the relationship between the securitization and the solar CCNs.
From staff's perspective, you know, we entered into a settlement with Ameren, Missouri about the solar CCNs. So that is, you know, we recommended the commission approve the 3 and the 4th be conditional.
Yep.
I mean, I think, I really can't speak to Mr. Seaver's analysis.
I'll ask them. But since it was in your, sir, I thought I would ask you.
Yeah, I was trying to point out that we didn't totally agree or understand or follow it, just for clarification purposes.
Thank you.
Any questions from OPC based on bench questions or commission questions?
No, thank you.
Any questions from Ameren based on questions from the commission or the bench?
I think just one line of inquiry. It may only be one question or 2 or 3, but I don't think it's very many. The judge was asking you essentially if the commission decides that the retirement is reasonable and prudent and securitizes, and I'm just gonna round to 500 million. Company's a little more, you're a little bit less.
Sure.
At this point. You know, what happens in the future? And I think what he's trying to ask is, does that have an impact on later arguments about whether the NSR permitting decisions were or were not prudent? Is that how you understood it?
Or any of the planning decisions.
Or any of the planning decisions? And I think your answer, and you'll correct me if I'm wrong, I think your answer is you don't see that it really has an impact because those are different decisions, and if those different decisions were later found to be imprudent in a rate case and you established harm in that rate case, then the commission would have the authority to impose a remedy. Is that right?
Yes.
And this has been a point that I think has been a little unclear since yesterday morning, so I'm going to ask you questions to maybe try to clear it up.
Okay.
Isn't the reason that that's the case is that the dollars to be securitized, assuming they are, assuming the commission says, yes, retire versus retrofit was the right decision, those dollars reflect investments that have been made in the Rush Island plant. I mean, put aside the decommissioning costs and some minor ones, but at least the plant balance. Those costs, you know, probably 460 or 70 million of the 500, they reflect investments that have been made in Rush Island, I mean, maybe as far back as the 70s, I don't know, but all in the past that were necessary to build it, keep it running, operate it, et cetera. And those costs have nothing to do with any of these decisions we're talking about. Isn't that right?
Well, to the extent there's any costs related to the outages still in rates, I mean, technically there is some cost there, but.
Okay, but you're not claiming that the company was imprudent for incurring the cost of the outages in 2007, you know, to doing the projects. You may be claiming, or you actually aren't at this point, but somebody may claim that not getting permits was imprudent, but
Well,
nobody's raised a claim, to my knowledge, that says you shouldn't have, you know, fixed the boiler component. You shouldn't have replaced those components from a, you know, operational reliability, availability standpoint. Nobody's made that allegation, right?
Okay, to clarify, because I think the judge was asking Mr. Majors about my position. My position is there were things that Ameren did that were reasonable, but there are things that they did or did not do that were unreasonable. We didn't calculate a harm for that because it is not known yet. And so while Mr. Majors was talking about imprudence, I think there was maybe a little inconsistency between staff on what we think is imprudent versus unreasonable. And I think that went to some of the judge's questions the other days about reasonableness and prudency.
But the staff is not challenging the prudence of the cost incurred in the past to build or maintain or to replace components or whatever. The staff is not challenging the prudence of incurring those costs, is it?
Those projects were done for availability, regaining availability, and improving efficiency, and were needed for Rush Island to have operated in the past, almost 20 years.
Well, those projects and all the other investment, whatever it is that's still on the books, was done to basically build and operate Rush Island over the last several decades, right? That undepreciated plant balance was incurred. It's been through rate cases. There's been no prudence challenge to those past costs. That $460 or $70 million, as far as you know, was prudently incurred, wasn't it?
They were included in rates. Or included, it is the remaining net book value of the Rush Island.
But you don't have
facility.
any memory of there being any proposed prudence disallowances about Rush Island costs, at least in the 10 or 15 years you've been at the commission. Rush Island projects, has there?
I don't recall any specifically, no.
Okay, thank you.
Any redirect from staff?
Good afternoon.
Good afternoon.
Do you recall talking with counsel for Ameren about the transmission cost upgrades?
Yes, I do.
Okay. Do we, and we're trying to stay out of numbers because that's confidential.
Out of numbers.
Do we have any range of transmission costs?
Well, so I think that number is fairly firm. And I won't say the number. Okay. Yes, I know. I will not. And Ameren council represented that it was out to bid, or maybe, and that is the reason that it is confidential. So, I think we'll have a better idea, maybe at some point in time.
Do we know if there was a range of transmission costs that Ameren used when it was doing its NVPRR calculations?
There is a range. I'm hoping you could point me to my testimony on that, but maybe not.
Just to save time, I think it's the existence of those numbers versus what those numbers are might be.
Okay,
Impactful
yes.
at this
So in past IRPs, yes, there was a range with some level of uncertainty around the transmission projects.
But that calculation, to your understanding, is how they determined if retiring or retrofitting was the better decision.
Well, there's two different uncertainties I talk about in my testimony. So, in past IRPs, and Mr. Michaels has several attachments to his testimony, and it's kind of points out the transmission upgrade costs in various IRPs, and those dollar values range. But the uncertainty discussion in my testimony is related to what was assumed in the 2020 IRP. I don't know if that helps, or if you have more questions about that.
Let's see if I can get at it this way. How could an order in this case hold customers harmless, even if we don't have firm numbers, but based on the information we already have? We need a buzzer.
Yes. They used a value.
Hold on just a second. Go off the record.
Okay, I apologize.
Let's go back on the record and go ahead.
Okay, so there is a value that was assumed in the break-even analysis, and that number is known. I think
And
is
how
your
could
question.
that be used to help hold customers harmless in the future?
I think the commission could order, in this case, something about that potentially.
Do you recall discussing with counsel for Ameren about the difference between something being well documented versus being a good or bad decision, and how those are different?
I do.
how can well-documented impact how regulators determine if a decision was good or bad?
Yeah, and I think we talked a lot about, well, Mr. Majors, I think, a little bit, and other witnesses talked about, you know, whether Ameren, Missouri could have sought a permit applicability determination from DNR or EPA, I think is OPC's kind of position. And the reality is, had they done that, we would have documentation to, you know, support their position. But we don't have that in this case. So,
Do you recall discussing with the bench the three concerns you laid out in your rebuttal, but the fact that no actual harm has occurred, no firm harm has occurred with those yet?
I do recall that discussion, yes.
And one of those was capacity.
Yes.
What is your understanding of how timelines work for plant additions?
I guess which plant additions?
Generating plant is probably the easiest.
Are you talking about IRP planning, or are you talking about the length of time it takes from an engineering perspective to develop and execute a project?
Yes.
I would need to know which project.
Maybe I'll try to shortcut it. Could a future capacity shortfall require present planning in your experience?
Yeah, I mean, what the shortfall potentially is related to is winter capacity. And so that type of project does take time to develop and execute. Now, Mr. Michaels talked about being able to get capacity from the planning auction. So there is that too. I mean, it's not like, well, staff's not trying to raise red flags and say there's this crisis. That's not what we're highlighting here.
In regards to the, that discussion you were having with the judge and the utility of a hold harmless provision or what impact it can have now versus in the future when those actual actions come in and are asked to be included in rates. Do you believe that a hold harmless provision has any help in actually quantifying the harm for future cases?
Judge, I'm going to object, and if my memory's faulty, I'm sure you'll tell me. I don't actually remember you asking anything about the hold harmless proposal. You did ask about possible harms related to transmission, but not about the hold harmless provision. And I also think Ms. Mers is asking essentially Ms. Eubanks to state a legal conclusion about, you know, what you can or cannot do. So I think it's beyond the scope of the questions, and I also think it's calling for a legal conclusion.
Would you please restate your question for me?
I'm going to try. Can a hold harmless provision help quantify the actual harm for later cases?
I'm going to overrule the objection. You can answer.
Yes, it's a number we know they used in their analysis in this case. You know, and to be clear, the first analysis and direct testimony in this case. And yeah, it's a number that is known and was used in the analysis to support the decision. And that's really the basis for it. And it would help in the future to track costs either above or below. So
I think this is all I have for you then. There was some discussion towards the end, I think, with both the judge and Ameren, Missouri, about how imprudence in one decision can interplay with not finding imprudence in another decision. Do you recall that?
I do.
Okay. Do you distinguish between if Ameren, Missouri's decision-making in total was reasonable versus if at the culmination of these events, if retiring was a better decision than installing scrubbers on Rush Island.
I do think those are two different questions, yes.
And do you believe that you can find one to be reasonable and the other to be not reasonable?
Yes.
And at this time, are there any other actions available to Ameren other than retiring or installing the scrubbers?
Objection, that does call for a legal conclusion. Given that we're under a federal district court order to close the plant.
State your question one more time, please. I
Are-
mean, I know that, I just want to hear exactly how it's worded.
I believe it's something like, other than retiring or installing the scrubbers, are there any other actions available to Ameren, Missouri?
I'll object to that question as being irrelevant. Actions available to Ameren, Missouri to do what?
How to treat and handle the
Hold
plant
on.
going forward?
Judge, the problem with
I
the
don't-
question is it requires Ms. Eubanks to decide whether, whether Ameren, Missouri, under the Clean Air Act and under the judge's order, can disregard or somehow do something different with the plan, having been ordered to close it. I don't understand why this witness has anything to assist the commission on that issue.
I don't know if I agree with you as to that, but I do agree with you as to I don't know without asking the court for another, if you decide you want to put on the scrubbers now, asking for leave of the court to put on the scrubbers or to modify the judgment again. So or maybe take up the plant and flee the country. So I do agree that whatever answer would, I'll sustain the objection, but not for the reason given.
All right, that's all I have, but thank you.
Is Ms. Eubanks appearing on other,
Uh,
well, I think her stuff's already in the record.
I think she is back for issue
Yes.
5.
Thank you, I forgot about that.
Yes, my
Ms. Eubanks, you may
testimony's-
step down.
Okay, thank you.
Staff, you may call your next witness.
Staff calls Sean Lange to the stand.
And after Mr. Lange, I anticipate taking a short break.
This is on.
Mr. Lange, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth? I do. Please sit down. Go ahead, staff.
Can you please state and spell your name for the record?
My name is Sean, S-H-A-W-N-E, Lange, L-A-N-G-E.
And did you prepare or cause to be prepared testimony in this case that has been marked as Exhibit 108, rebuttal testimony, and Exhibit 109, the surrebuttal testimony?
Yes,
And do you have any corrections to that testimony?
not that I'm aware.
And is that the information contained within true and accurate to the best of your knowledge and belief?
Yes,
And if I asked you those questions today, would your answers be the same?
yes,
At this time, we can mark Exhibit 108 and 109, but Mr. Lange will be back up for issue 5, so we will hold off on offering it and offer Mr. Lange for cross.
Any cross-examination from public counsel?
No, thank you.
Any cross-examination from Ameren?
No questions, Judge.
Any commission questions? Hearing none, I have no questions for you, Mr. Lange. So you may step down.
thank you.
Staff, you may call your next witness.
Staff calls Brad Fortson to the stand.
Mr. Fortson, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth? Please be seated.
Can you please state and spell your name for the record?
Brad, B-R-A-D, J. Fortson, F-O-R-T-S-O-N.
And did you prepare or cause to be prepared rebuttal testimony marked as Exhibit 104 and corrected rebuttal testimony marked as Exhibit 105 in this case?
Yes,
And do you have any further corrections to that testimony?
not to my knowledge.
And is the information contained within true and accurate to the best of your knowledge and belief?
Yes,
And if I asked you the same questions today, would your answers be the same?
they would.
I believe Mr. Fortson also goes up for issue 5 again, so I will hold off on offering his, but we will tender Mr. Fortson for cross.
Thank you. And I decided not to recess simply because Mr. Lange was so short. I may, at this point, because we only have Mr. Seaver left on this issue, I may go ahead and try and push through before we take a break. Any cross-examination from the Office of the Public Counsel?
No, thank you.
Any cross-examination from Ameren, Missouri?
No, no, thank you, Judge.
Any questions from the commission? I have no questions for you, Mr. Fortson. So you may step down. And the last issue as to this witness is OPCs, or public counsels.
Public counsel calls Mr. Seaver to the stand.
I'll remind you, Mr. Seaver, that you're still under oath.
Understood.
I believe I jumped the gun with him a little bit in his, well, I don't know, did I offer your testimony yet?
I believe so.
I believe you did. Actually, it's already been admitted over objection, and the corrections have been noted.
Okay, I thought I'd offered it, but I hadn't noted it properly in my record keeping, so since testimony is already in evidence, I offer Mr. Seaver for examination.
Any cross-examination by the commission staff? Any cross-examination by Ameren, Missouri?
No questions, Judge.
Any questions from the commission? We may need to go into camera for some of my questions. I've just got a few, and I'm going to try and keep it short. And you tell me, Mr. Seaver, if we need to go into camera, in camera. Now, Public Counsel's Office is recommending a disallowance of some kind for prudence. Is that correct?
That is correct.
And what is that disallowance for?
So that disallowance is recommended in my testimony as a way to reduce the amount of securitization. So if you choose to go ahead with if the commission chooses to go ahead with securitization, the Office of Public Counsel is not recommending, and in my testimony, I'm not recommending that you don't securitize it. And I understand that in order to securitize it, you'd have to determine that the decision to retire is prudent. But I think that there are issues related to, again, as Mr. Williams pointed out, the continuum from the beginning of this with the decision not to get applicability determination or pursue NSR permits from the EPA up to the decision that's now under consideration. And it is a way to reduce the cost of securitization for customers. I think that answers the question.
And what's the imprudent decision that public counsel is seeking?
So, in my opinion, and this is in my testimony, because I believe the position statement OPC doesn't take a position on this. So, let me just walk you through how I got to this, right? So, I don't see how the company can distinguish between the decision to retire Rush Island and securitize and the upcoming additions of solar and wind and batteries and gas. And that also goes along with its decisions to retire and presumably securitize other plants as well, coal plants. So my figure of the disallowance was based on an actual figure of something that I considered to be a replacement for part of Rush Island at the time. It was actually presented by the company. It wasn't just, oh, well, it'll be 1,000 megawatts of wind right here, right, or in this time period. I could have done something different. I could have said, well, let's see, what would it take to replace Rush Island with renewables? And of course, if you replace a coal plant with renewables, you need some kind of a backup for dispatch, because even if you can run, even if you get, let's say for an entire week, you get all of your peak and all of your base load from renewables, because you got a bunch of wind and you got a bunch of solar and it's an advantageous week, right? Then what about the next week? You need backup for it as well. So you have to consider not just whatever Mr. Michaels considered, 1,200 megawatts of combined cycle, 800 megawatts of simple cycle. You have to consider the other things as well, because, well, I'm getting a little ahead of myself. So I could have gone much further and said, maybe that's 3.6 billion. Maybe just looking at the replacement for Rush Island from the period of 2025 up to the period when we saw in exhibit staff exhibit 118, when that capacity balance changes in 2025, and then we only see it climb back up to what it was before around 2030. Well, the company's planning on putting in 1,800 megawatts of solar, 1,000 megawatts of wind, 400 megawatts of batteries, and then some gas as well. Well, that's a lot of money, right? And I didn't take all of that and then subtract my calculation of the scrubbers, which was based on an average from various estimates that I had in front of me, and then take that amount and subtract that from securitization. That would have given you a positive, and it would have been no securitization because there'd be nothing left. But that is, in essence, why I recommended a disallowance of something and why I used the 4 solars. So even, like I said, in my testimony, I made corrections because the one is not considered anymore. But it's not like those 150 megawatts from that plant are not going to be at some point added. So I still feel that the 4 is a good way to calculate this.
So would it be fair to say that basically you came up with a fairly wide range and you picked what you felt was most reasonable within that range?
Yeah, that's a good way to put it. I think it's just a zone of reasonableness, you know, and I think it's a low amount to disallow, in my opinion. Small amount, I should say.
Okay, I have no more questions. Any recross based upon my questions? Commission staff?
I think very briefly. In your discussion with the judge, you discussed how you viewed Ameren's capacity position work papers to come to your recommendation on what to remove and what seemed fair. Is that an accurate summary, or?
I didn't use these work papers to come to that. I just was referring to them right now as a, you know, way to, a tool to visualize what I was doing.
No. Thank you.
Any recross from Ameren, Missouri?
Just
Or in this case, questions based upon bench questions.
Thank you. Mr. Seaver, no cost associated with the 4 solar facilities, or the 3 if you prefer, since you sort of amended your testimony here today. No costs associated with those solar plants are in rates today, correct?
That's correct.
They haven't even been proposed, the cost of those plants hasn't even been proposed for inclusion in rates yet, has it?
No, I mean, it's assumed that it will be, but yeah, no, it hasn't been proposed.
The $500 million the company seeks to securitize in this case, none of that $500 million consists of any expenditures on the solar plants or any other future addition, batteries, gas, anything else, right?
That's correct.
That's all the questions I have, Judge.
Thank you. Any redirect from public counsel?
Thank you, no.
You may step down, Mr. Seaver.
Thank you.
It is now 3:08. Why don't we come back at 3:20? And we'll go off the record and recess. All right, we are starting issue 4, which is amount to finance, and that is an A and a B. A is what amount of abandoned Rush Island capital project cost should be financed using securitized utility tariff bonds, and B is should staff's proposed exclusion of the costs of the abandoned Rush Island scrubber study be adopted. Is there any reason that we can't keep the witnesses on the stand for both A and B at once?
There isn't, and just a point of clarification, Mr. Burke won't know anything about A, and I think the parties know that, but I just wanted you to know that, Judge. But Mr. Lansford will know about A from that standpoint, and I think the other witnesses, Mr. Majors is probably A, and Mr. Payne is probably B for OPC, just to orient you.
Thank you. I may just ask them when they get up to clarify, just so that everybody understands.
Judge, would it be, I don't think there are any other commissioners on, and I don't see any here, although maybe the chair's coming back. Would it be helpful at all for a brief mini opening to orient you to this issue, particularly the studies issue? Or if you don't find it helpful, I don't have to say anything, but I could sort of set the stage in this mini opening if it'd be helpful to you.
I believe that I had said that any party that wants to do a mini opening on issues may, so you certainly may do a mini opening on this, and it might be very helpful to me.
Would you like for me to just go ahead and briefly do that and before we take Mr. Burke, or?
Yes, I assumed you were.
Okay, thank you. In the 2009 to 2011 timeframe, the company engaged 2 engineering firms, Black & Veatch and Shaw, to conduct capital projects involving preliminary Rush Island site-specific studies relating to the possibility of installing scrubbers at Rush Island. The reason that the studies were done is because the then proposed clean air transport rule, I believe, and mercury and air toxics rule, 2 EPA rules, as we understood the proposal at that time, were going to require all of our units to be scrubbed over the next several years. As it turned out, the final rules came out less stringent than they had been proposed. And because of that, and because of a large emissions allowance bank that Ameren, Missouri had, and because we were able to keep looking for alternatives, and we found one, that is to burn ultra low sulfur coal, we didn't have the engineering firms, completely finalize their reports and so on, and we did stop the projects and didn't proceed with scrubbers. And Mr. Burke can discuss that in more detail. Because of the possibility that EPA could have issued additional rules at any time after that 2009-2010 timeframe, and that could have meant that using the ultra low sulfur coal or using allowance wasn't feasible anymore, wasn't economic anymore, we didn't abandon the projects. These are QIP projects. You can remember your judge probably from Liberty, they had some QIP projects as well, for some environmental QIP projects, as a matter of fact, and they abandoned those, and the commission did securitize those projects in that case. But we didn't abandon the projects, from a accounting perspective, which is actually going to happen when the plant closes, because it was possible that we might need to add scrubbers. It was undisputed. It's undisputed, I think. I don't think anybody's alleging that the projects were not undertaken prudently or in good faith. It's undisputed that they're site-specific to Rush Island. Staff speculates that they may no longer be useful, but on that basis alone, they say they shouldn't be securitized. But the evidence will show, and I think Mr. Burke can certainly address this for you, that in fact they do have usefulness. And regardless, I don't even think that's the test in any event. But Mr. Burke can discuss why we believe they are useful. So thank you very much.
All right, thank you. Mr. Burke, you were here yesterday, but I'm going to go ahead and swear you again. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Thank you.
Mr. Judge, this is the last time Mr. Burke appears. Should I just go ahead at this point and move his testimony into the record? Because I don't think that's been done.
Go ahead, Mr. Lowry.
I'd offer Exhibits 6 and 7, the direct and sir rebuttal testimonies, respectively, of Mark Burke into the record.
Are there any objections to admitting Exhibit 6, the direct testimony of Mark Burke, and Exhibit 7, the surrebuttal testimony of Mark Burke, onto the hearing record. I hear and see no objections. Exhibit 6 and 7 are so admitted onto the hearing record. Any cross-examination from the commission staff? No, thank you. Any cross-examination from the Office of Public Counsel?
No questions at this time, thank you.
Any commission questions? Well, I'm going to take the bait. So, since Mr. Lowry said that you would be able to explain to me why this abandoned study is used and useful, I would like to know.
So, as Mr. Lowry indicated, in 2008, we hired basically Black and Veatch and Shaw to do essentially parallel studies for us. And the reason we did that was because we recognized that the care rules and some other potential rules that were coming down the pike may require us to put scrubbers on all of our plants. And we knew that based upon how the rules were being laid out, that the timeframes would be tight. So one of the things that we benefited by was actually having both of these firms come in, look at the specific site at Rush Island, actually lay out detailed plans of where the scrubbers would be located, all the way down to the specific equipment we would use. Now, recognize while this was going on, we were also in the middle of constructing the Sioux scrubber, so we were learning things from that. We were incorporating it in, and ultimately what was developed allowed us to have essentially a full spec that we could go out on the street with to an EPC, an engineer, procure, construct contractor, and build the scrubber. Now, you know, I know in some of the testimony it indicated that, well, that really didn't give you any head start. But the reality is this study started in 2008, and we got the detailed information. Shaw's information came in really the final in 2011. So it took us a couple of years to work through all the details associated with installing the scrubber at Rush Island. And we had the studies to a point where in the very near term, we could go out on the street and say, okay, here is the plan. The Black and Veatch study was almost 1,400 pages. The Shaw study was about 4,000 documents, all the way down to physical layouts and drawings, specific equipment specs. It was very detailed. I've gone through it. I haven't gone through all 4,000 documents, but I've gone through the study, and I've gone through both of them. And from an engineering perspective, they were ready to go. And so we believe that what it would do would allow us to shorten the time frame as much as possible from the time, let's say, a rule was finalized to the time we had to have the scrubbers on the plant. So that's the reason, that's the reason that we believe that that they were beneficial, and that's the reason that we believe it would have helped us comply with the potential rules that were coming down the pike. This is not unlike other studies that we do and other ways that we look at things for other types of equipment that we put on our generating plants.
Okay, I know you mentioned that, the Sioux plant. Was this study commissioned for all of the coal-fired plants, or was this study commissioned specifically for the Rush Island?
It was commissioned specifically for Rush Island. One of the things that we recognized with Rush Island and Labadie are pretty similar plants. So we recognized as we worked through the spec and the detailed design for Rush Island, we would also potentially get some benefit if Labadie needed to put scrubbers in. They're both basically have 600 megawatt tangential fired units. The site layout's a little different, but essentially, ideally, if we would have had to have put scrubbers on all 6 units, 2 at Rush and 4 at Labadie, we would have attempted to use the same equipment because we'd want to share it between plants. That is the least cost way to do it. So you'd want to share spares, you'd want to make sure that you could design it similar.
If you had to put on scrubbers at a different plant, would you have to commission a new study?
If we looked at Labadie and said we need to put scrubbers on at Labadie, we would pick up some of the information that's in this Rush study and we would use it as a starting. It's not going to be exactly the same because the physical layout could be a little different, but a lot of the equipment and a lot of the specifications on, let's say, sulfur removal and things like that would be the same. I'm sure the technology that we picked would have been the same because we had chosen a wet scrubber technology already for Rush Island in these studies, and we had laid out how we were going to provide all the electrical and everything. So a lot of that, could potentially be used at Labadie.
And not to split hairs, I understand the concept of could be useful to Ameren in the future, but I don't see how that makes it used and useful now.
Well, I believe that in doing this analysis, it was used and useful for Rush Island. We used the estimated cost of the scrubbers that we got out of this study to determine even whether we made the retirement decision or not. We had confidence because of the analysis that was done that we knew roughly how long it would take to construct the scrubber and how much it would cost.
Then why is it an abandoned project?
It turns out being an abandoned project because we never actually built the scrubbers.
Was the Black and Veatch study the basis for the economic analysis that was performed, determining that it was more beneficial for Ameren's ratepayers to retire the plant than to install the scrubbers?
Yes, I believe it was the basis.
It was the only economic basis?
I don't know that I can say that, Judge, but it was from an engineering perspective, the information that was provided to Matt Michaels had come out of that earlier analysis of what we believed it would cost to put scrubbers on at Rush Island.
But just to clarify, the study is not associated with any plant that was ever in service with the completed scrubbers.
That is correct.
Thank you. Any commission questions? I hear none. Oh, I'm sorry. I jumped the gun there.
Took me a minute to think, Judge. Apologies. Good afternoon, Mr. Burke.
Good afternoon.
Just following on Judge Clark's question, you said that the Black and Veatch studies were part, at least, of the rationale of the economic basis for not installing the scrubbers, but instead retiring the plant.
Yes,
Right.
Commissioner. Yes, that's correct.
You also said that the studies may have not been able to be used exactly to install the scrubbers, but they would have been useful if you had chosen to install the scrubbers because it would have saved time. Is that correct?
That is correct.
Okay.
That is correct.
Would that time savings also have translated into dollar savings should you have chosen to install the scrubbers? For example, if you had to commission another study to actually, or another engineer, actual project and engineers, would it have saved them, time and money in that estimation?
Absolutely, because you would have had to go through and basically do all of that. Like I said, the studies themselves started in '08, and it took almost 2 years to do them. And you have to do them before you can install the projects, because you can't even bid the work out until you do that.
Yeah. I'm going to go a little out of order today because I was listening online last night when you testified, but I don't like asking questions virtually. I find it difficult. So I am going to go back to the last issue a little bit. You mentioned in your testimony last night that the issue that you thought was before the commission was whether or not the decision not to pursue an SR permit was reasonable and prudent, and that's the decision you thought the commission had to make. Is that right?
That is correct.
According to that interpretation, do you also think the commission do you think that, from your view, has to lead into a decision that the retirement, the decision is reasonable and prudent to retire or abandon? You think we have to make the decision that you suggested last night to lead into the second one, or do you think they can be mutually
They're two
exclusive?
separate. They're
Okay.
mutually exclusive. They're two separate decisions.
Okay. Just want to clarify that because I previously discussed with your council, I think on day 2 or something, just distinguishing those.
Yeah, they're two separate.
Okay. Also going to now change subjects to something else. Earlier today, I discussed with Matt Michaels concerns over resource adequacy generally. How is Ameren generally planning for resource adequacy concerns if you're going to hit a capacity shortfall in 2025 of 300 megawatts?
So what we're doing, basically, Commissioner, we use our integrated resource planning process to do that. We do recognize that the MISO has gone to a seasonal construct. And we also recognize that, like a lot of the rest of the United States, there's a lot of renewables being added. And one of the things that we've done with the last IRP, and we will do them with subsequent IRPs, is we're looking at the resource needs much more granularly. And by that I mean it's hour by hour, day by day, because we recognized a few years ago that, especially when we got into some of the winter issues with Uri and things like that, that you can't just look at the summer anymore. You have to look at 24/7, 365. And so when we look at it that way, we recognized that that as we integrated more renewables on the system, we needed more dispatchable generation. And so going forward, that is one of the things we're going to focus on. I think when you look at our coal fleet in general, and this is one of the things that that utilities have to deal with, is you can't look at it without assuming there's going to be additional regulation in the future on those plants. And I think you also have to look at it. And I've worked. I started in nuclear, but I spent most of my time in the coal plants, so I understand it. As they get older, they're going to have to retire. You can't keep. Merrimack was almost 70 years old when we retired it. What you start to worry about, you can replace some components in there but you can't replace everything. And so it starts to become a reliability and a safety risk. So as we look at our system, we are really trying to figure out how to continue to meet the capacity and energy needs of our customers, along with having the right mix of dispatchable and renewable. It's not easy because not only are we seeing more pressure on some of our existing resources, but we're also seeing lately more and more load. I mean, we're starting to see interest from data centers and other areas, and I would expect in the future that we're going to have to do more frequent IRPs. Some of it could be because we have a unit retiring like Rush Island was doing, but some of it could be that we're picking up additional demand and load in chunks. In the past, you know, we could look at our load growth and it'd be somewhere between 1 to 1.5%. It followed the GDP. You could almost bank on it. And then when energy efficiency came in and LEDs and everything, it went away from that and it kind of flattened. And what we're seeing now is the loss of some of the baseload generation, but the additional of load. But now it's chunks. I mean, when data centers come in, it's not 5 or 10 megawatts. It could be 200, 250. It could be 500 or more. And those are, when our peak load in the summer is 7,800 megawatts, those are big chunks. So I think to answer your question, the way we're going to have to do it is we're going to have to more frequently continue to update our integrated resource plan. And we're going to have to be able to ensure we have enough dispatchable resources and enough total resources on the system. You know, I think what we found is it's not out there easily to get in the marketplace. I think we've seen that from MISO. And so the other thing we did in addition to looking at the IRP more granularly is we recognized in order to ensure that we can keep the lights on, we're gonna have to build this stuff ourselves.
That's interesting. When I asked Mr. Michaels, you know, how do you plan to make up the shortfall? The answer, and I'm summarizing, was buy it.
Yeah.
But that's a problem because there's nowhere to buy.
It's not always there.
Not always there.
It's not always there.
Which is also a concern.
Mm-hmm.
So, just want to make sure that we're, you know, taking these things into account as we make these decisions. So.
Yeah, you know, from an engineering perspective and an operating perspective, the last thing we ever want to happen is the lights to go out, period. We know from talking to our customers that the two most important things to them are reliability and affordability. So we're constantly trying to balance that, but generally, if you don't have the reliability there, the affordability is probably less important. So we have to make sure first and foremost we can ensure that we have reliable electricity, and that's what we're planning to do.
Well, thank you, Mr. Burke. Appreciate the judge's indulgence in letting me cross issues. Thank you.
Thank you, Chair. Any redirect based upon commission questions from AARP or Consumer Council of Missouri?
No, thanks, Your Honor.
Any redirect from the commission's, or I'm sorry, recross from the commission staff based upon commission questions?
Just very briefly, and just for my own clarification, when you were discussing with the bench the applicability of the studies to the different plants, I thought at one point I heard you say Sioux, and then I thought I heard you at one point say Labadee.
Let me clarify
Okay,
that
thank
for you.
you.
Yeah, I'm sorry.
No, it's okay.
That was probably my fault. So at the time that we were doing the study for Rush Island, we were in the middle of constructing the Sioux scrubber. So as we were building that, we were learning things through that construction. Maybe things around materials, things around layout and that we incorporated into the Rush Island plan. So the study had nothing to do with Sioux. Sioux was already underway from a construction perspective. And the reason that I said it would, you know, some of the parts could be applicable to Labadee is because Rush and Labadee the units themselves are fairly identical. They're all 600 megawatt units. Some of the parts are even interchangeable. So that's why.
Okay, thank you for that. And then one other clarification. Do you recall discussing how you and Matt Michaels used the cost of the cost of the scrubbers that came from the study to do your NVPRR calculations?
The calculations that Matt Michaels did around retirement, is that correct?
Yes, and if you don't know this, that is okay, but do you recall, did those calculations include the cost of that study?
I do not know that.
Okay, thank you
Counsel,
very
I'm
much,
sorry.
though.
Okay.
Any recross from the Office of the Public Counsel?
Yes, thank you. Good afternoon, Mr. Burke. How are you doing?
Good afternoon.
You said, as I understand it, that the work that was being done on scrubbers at Sioux informed the study for putting scrubbers on Rush Island. Is that correct?
Yes.
Are Sioux and Rush Island, I guess I'll use the word sister plants, like you indicated Rush Island and Labadee are?
They are not sister plants, but the type of scrubbers that we were installing at the Sioux and the type of scrubber we were going to install at Rush Island was a wet scrubber. So we were taking learnings from that, learnings how we fed the power through, things like that we were using. So they weren't complete apples to apples, but they were close in a lot of regards.
So when you say sister plant, are you saying they're essentially identical, or?
Are you talking about Labadee and Rush Island now?
Well, you used the term sister plant, so yes, it would be your description of Labadee and Rush Island.
So Labadee was built, so there's 4 units at Labadee. They were built in 1970 through 1973. They were combustion engineering, T-fired, which means they're tangential from the walls. And Rush Island was built in 75 and 76. And they're also combustion engineering T-fired units. So yeah, when you look at them from an industry perspective, they each have 6 coal mills per unit. They each use similar boiler feed pump. There's a whole lot of similar things that the units have. So I think calling them sister units, not completely identical, because one of the things I think that we found was as Labadee was constructed, there were some shortcomings. The furnaces may not been big enough, so they made them a little bigger at Rush Island. There were some other things that they found that they improved as they built Rush Island, but essentially very similar.
When was Sioux originally built?
It was built in 1966.
And why did you first put scrubbers on at Sioux?
The scrubbers were installed at Sioux first because Sioux is a cyclone-fired unit, different than Labadee and Rush Island. And in order to get the full capability out of Sioux, we could not use a complete blend of low sulfur coal. So we had to, even to today, we have to mix some high sulfur with low sulfur. So essentially, Sioux was our dirtiest plant from an SO2 perspective, and we recognized that at some point we would probably potentially have scrubbers throughout the system. So since Sioux was our dirtiest plant, we felt we'd put it on there first. We had to comply from a system perspective, and it cleaned up the one that emitted the most sulfur first.
And then you said you had a cost estimate for scrubbers at Rush Island from the 2008 study and information about how long it would take to build the scrubbers at Rush Island from that study.
Yes, sir.
What was the cost estimate?
If I recall, and it probably doesn't have all the loaded cost and everything in it, but it was around $720 million.
So it'd be kind of a preliminary estimate?
It was a preliminary estimate, and again, that was based upon, I think if I remember correctly, starting scrubbers, completing one of the units in 2015 and the other one in 2016, again, to comply with the potential CARE and CASPER requirements that we saw coming down the pike.
And when did you get that estimate?
It would have been done when the studies were
2008 or 2000?
The studies were started in '08 and completed in 10 and 11, so it's been in that time frame.
Then you got some questions about resource adequacy, and I keep hearing the utilities talking about the capacity requirements that the RTOs and ISOs impose on them. Are those capacity requirements necessarily sufficient for the utilities load itself?
So MISO, when they went to the seasonal construct, they actually, when you say capacity requirements, it's, you have to provide enough generation to supply your demand plus a reserve margin. And so in the MISO construct, and I'm not an expert on this, but in the MISO construct, by season, that reserve margin can vary. So what the RTOs have started doing, which I think is actually a good process, is when you get into the winter, when you may not have the same level of, let's say, solar assets available, they very well, they may make you carry a higher reserve margin than you would in the summer. So prior to this seasonal construct, for instance, we had to carry, be able to meet our demand plus about, I think it was 12 or 13% in addition to that in the summer. And that accounted for the variability in units and things that may happen. I think it's actually going to, seasonally now it's changing. So we have to accommodate essentially every season.
Well, isn't a utility better off if it's long than if it's short on capacity?
I would say from an operating perspective, you would be better off having more generation than less.
Callaway was down during Storm Uri, was it not?
I'd have to go back and look, but I believe it was down during one of the cold spells with the generator issue.
And Ameren, Missouri was still long enough that it didn't have to reach deeply into the energy market, correct?
I believe that was correct, but I think we were close. We were close.
You weren't like Liberty and Evergy West,
I
right?
can't speak to them. I will say that, one of the things that we have seen over the last several years is that our winter peak is getting much closer to our summer peak than it had been in the past. And so in the past, you may have seen, for instance, let's say a summer peak of 7,800 megawatts, and in the winter it may have been in the mid sixes, somewhere in there. I think over some of those times you were talking about, we actually were into the low sevens in the winter. So some utilities are actually seeing it get much, much closer, and we are seeing it get closer over time.
You talked about now getting chunky load. Wasn't Noranda a pretty good chunk of load?
It was definitely a chunk of load, that's correct. It's
Yeah,
500 megawatts, if I recall.
And when was that Ameren started serving Noranda?
I don't recall the exact year it did.
Approximately?
It would have probably been in the early 2000s, somewhere in around there.
So you have had some experience with chunky load.
Well, when you say chunky load, Noranda itself was, and by chunky load I meant it's being added in large chunks, and that's what Noranda was. But Noranda itself it's just like data centers. It had a capacity factor that was pretty high. It was probably 95%.
And when you say capacity factor, you mean it was using the same amount of electricity 24/7?
Pretty much 24/7. That's right. That's right. So yeah, it was.
Thank you. No further questions.
You're welcome.
Any redirect from Ameren?
A little bit, Your Honor. Mr. Burke Mr. Williams asked you, I think he asked you why was Sioux scrubbed, and I think you explained it was the dirtiest plant, and you had some system-wide SO2 targets that needed to meet, right?
That's correct.
Can you explain why the company was able to avoid scrubbing the other units?
Yes, the reason that we were able to avoid scrubbing the other units is as the CARE and CASPER, as the rules were finalized, and the market went to one that also had an SO2 credit bank. One of the things that we recognized is that we could burn, especially at Rush and Labadie, ultra low sulfur coal, and use that with our allowance bank. And we had a pretty good allowance bank because we had switched to low sulfur coals in the mid 90s on these units. And ultimately, we could do that and comply with the requirements, with the regulations, without having to scrub the units. And we believe that in doing that, it was definitely to the benefit of our customers.
There were issue was raised earlier in the hearing. I think there were some questions from the bench, and it relates to this question about why you didn't have to scrub the other plants. Seems like Evergy, for example, had to scrub all their plants. Was there something different about the coal or the allowance banks or something that between Ameren and Evergy that might have explained that difference?
Yeah, I believe that we had a larger allowance bank, and I think that was because, when Ameren, or is it time when Union Electric switched over to lower sulfur coals, we were one of the early ones in the industry to do that. And because of that, I think it allowed us to have a larger bank, and we utilized it.
So if Ameren, Missouri had significantly less allowances, it might not have been able to avoid the scrubbers, right?
That's exactly right. We may have made a different decision, but we recognize that that the cost of installing the scrubbers, and then the cost of operating the scrubbers, because there's also an O&M component that goes with it, that for us, we could purchase the ultra low sulfur coal, and it was beneficial. I believe, if I recall, we even came down and we actually talked to the staff about kind of our compliance plan around the ultra low sulfur coal.
Mr. Williams, he also asked you about the Black and Veatch and Shaw studies and the cost estimates, and I think this is probably clear if you think about it, but you said they were assuming installation in 2015 and 2016, right?
That's correct.
Does that mean that the $720 million figure you mentioned was probably in 2014 or 15 or $16?
Oh, absolutely. Yeah, and it would have had to have been. And I realize that when we talked to the court and when we went through the NSR, that the cost was higher than that, but it would have been escalated.
Judge Clark asked you some questions about used and usefulness. Do you remember that?
Yes, I do.
Am I correct that anytime you have a QUIP project that did not result in a project and it gets abandoned, that QUIP project never became used and useful, right?
That is correct.
There's some QUIP projects in this case that nobody's opposing securitization of it. Is that right?
That's correct.
And again, that they couldn't be used and useful either because they never came to fruition, right?
That's correct.
That's all the questions I have, Judge. Thank you.
Thank you. You may call your next witness.
Call Mitch Lansford back to the stand.
And Mr. Lansford is here for 4A, is that correct?
Yes.
Thank you.
I don't think he knows a whole lot about the scrubber studies.
I'm going to go. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth? Please be seated.
And this is not the last time he appears, so I'm not going to offer his testimony at this time. and I tender in for cross.
Any cross-examination from, AARP is no longer in the room. Any cross-examination from the commission staff? Any cross-examination from the Office of the Public Counsel?
Thank you, no.
Any questions from the bench?
Yes.
Or from the commission, I'm sorry.
Yes.
Go ahead.
Good afternoon, Mr. Lansford.
Good afternoon.
I've been trying to locate, and I'm sure it's in all of this testimony, I've had staff looking as well, the value of the scrubber studies, and I assume that it is in the difference between is that, unless it's confidential, I don't assume that it is, but,
I don't think it's that. It's that we're taking A and B together.
okay. He's on B, he's on both. Yeah.
Can you answer that question?
I can answer that question, yes.
I apologize.
That's okay. I'm just trying to locate the difference between the value of the scrubber studies and the difference in staff and Ameren's position on this issue.
Yes, I can help clarify that. I'm just going to turn to one of my schedules here. If I look at Schedule MJL S5 for my surrebuttal testimony, line 4 references abandoned capital projects and totals $12.9 million. And if you compared that to Mr. Major's similar schedule, I don't know the exact reference. On that same line 4, he would have $3.9 million under the abandoned capital projects line. The difference between those two amounts is $9,032,646, and that's the value of the scrubber study we're talking about.
Thank you.
Are there any other any other commission questions? Commissioner Holzman, please go ahead.
Thank you. That scrubber study, when did that occur?
I'm sorry, Commissioner Holzman, I don't have a lot of knowledge around the study itself. Mr. Burke had some of that knowledge.
Are we talking about a single study?
We are a single study as it relates to Rush Island.
And my understanding is that, this study is one of the ways that we can discern whether investing in the scrubbers was going to be in the best interest of the ratepayers versus retiring the coal plant. Is that accurate? That the study helps us get there?
Commissioner Holzman, would you like me to recall witness Burke? I believe he's the witness for that.
I'm asking from a high level perspective. I don't know that, maybe, not yet.
Okay.
Not yet. Let's see.
Let me know.
See what. Would you agree that the study is one of the ways that we can discern the difference in value for the ratepayer between installing the scrubbers or retiring the coal plant?
I think, and especially as I listened to some of the testimony from earlier today, that study helps us understand what's necessary to scrub the Rush Island plant, both units there, and does help inform the analysis that Mr. Michaels performed, that got to or helped us decide whether or not to scrub the plant or
Okay. And the study cost $9 million.
does.
Absent the study, would we have the data necessary to make an informed decision about which direction is in the best interest of the ratepayers?
I'm sorry, I don't really know whether we would have the information that Matt Michaels would need to perform the analysis or not. I mean, I guess I do know that the headroom that existed in a lot of the scenarios that he evaluated had tremendous headroom, but
Thank you. Judge, if you could recall Burke for just to answer this one question, I would appreciate it.
Absolutely. Mr. Lansford, will you step down? And at this time, I would like to recall Mr. Burke. I'll remind you, you're still under oath. Go ahead, Commissioner.
Thank you. My apologies for having asked you back up here.
No problem.
So you might have heard my question. I'll repeat it. For starters, we're talking about one study with the expense of $9 million to determine the value of the scrubbers for Ameren, Missouri. Is that correct?
It was, we called it a study, but we actually commissioned two separate engineering firms.
Okay.
And they did it. And the reason we did that is because we wanted to get cost and schedule certainty.
Was that $9 million split equally between the two firms?
I don't know that because we just had it in a work order. But it was, I would tell you from the output of both firms, it was probably pretty close. 'Cause
Okay.
it was pretty detailed, both firms, on what they provided.
Would we be in a position to accurately predict what was in the best interest of the ratepayers without the reports?
In my opinion, no, because we went through, it took 2 years to get to a point where we had schedule certainty and cost certainty. And so we based future decisions and escalations off the numbers that came out of that study.
Do you think Ameren's position would be different if those reports had come back and said that it's economically feasible to install the scrubbers and extend the life of the plant?
Well, what the studies did was they just determined the total cost of what the scrubbers would be and how much time it would take to construct them.
Okay.
And then so Matt Michaels took that information, and really the engineers developed that and put it into his analysis. So the cost was the basis for his analysis
Okay.
from a scrubber perspective.
Okay. Thank you. Thank you. Judge, I apologize, did we already hear from staff on 3B or 4B? We have not. Mr. Majors?
No, Commissioner, we have not.
Okay, thank you. That's all the questions I have now. Thank you.
Just a second. There's due process concerns.
Sorry.
Any redirect from the commission staff?
I'm sorry, but I have just one.
You don't have to apologize for that.
So the studies were completed in 2011, is that correct?
That's correct.
So
10 and 11.
10 and 11. If Ameren wanted to evaluate on closing Rush Island versus retrofitting, we can imagine the court cases don't play a part in it, just that decision in an IRP. They had that information and starting in at least 2011, is that right then?
That would have been correct.
Okay.
Yes.
Thank you very much for clarifying, I appreciate it.
Any recross from the Office of the Public Counsel?
Yes, I do have a few. When did Ameren, Missouri put scrubbers on, Sue?
The scrubbers were completed in 2010, I believe.
And we had a discussion earlier about what occurred at Sioux informed the studies that were done for Rush Island, correct?
Informed some of the equipment analysis.
And how much did it cost to put the scrubbers on at Sioux?
From what I can recall, it was somewhere. It was around maybe six. I'm going off the top of my head here, okay, but it was around 600, 620, somewhere in there.
620 bucks? That
No. Yeah, I think it was around 600 million to 620 million, somewhere in there.
So from your testimony, well, how much different were the scrubbers at Sioux versus scrubbers at Rush Island or Labadee?
Yeah, so that's a great question. Sioux is a 500 megawatt unit. Rush Island is a 600 megawatt unit. There were some differences. We had to replace the fans at Sioux because we didn't have enough air capability. At Rush, the design was far enough along that we felt we could just replace the motors, put bigger wheels on the fans, so there were some nuances and differences. But Rush was a bigger unit, and so you would expect it would cost a little more to put it on than what it cost at Sioux, which it did.
So the Sioux cost of 600 to 620 million was in 2010 dollars, right?
That's correct.
And the estimates you had of, what was it, 700 or 720 million for Rush Island were 2015-ish?
Well, they would have
Dollars.
been, they would have, I mean, the studies would have been completed in 2010 and 11. And then they would have, you know, escalated. They had built up, from what I recall, and I didn't read through the details, but the study built up the cost through the construction period. And so it would have been escalated throughout that construction period. So 2015, it would have started in construction in 2011 and ended in 2015.
Well, okay, I understand there would have been a construction period over time, but the all-in cost by the time you got done at 2015 was was estimated to be in the neighborhood of 700 to 720 million.
About 720.
And you would expect, I guess, similar types of escalation if you were to push the numbers out to, say, 2021 or 2022?
I'm an engineer, I'm not a finance expert.
Well, have you ever seen costs go down with time?
No, no, they do not. So it would have been escalated. It would have been escalated. for
And I'm
sure.
not asking you to quantify. by
No,
how
it would have
much,
been
so.
escalated. So, yeah.
Thank you. No
You're
further
welcome.
questions.
Any Ameren redirect? Okay. Mr. Burke, I appreciate you sticking around to be able to answer these questions,
No problem.
and you may step down.
Thank you.
Mr. Lansford, if you will come back up, we will continue your testimony, and I'll remind you again that you are still under oath as well. And bear with me just a moment while I find where I was. Would you explain to me briefly the tax concern that was brought up by one of the other parties and why you don't believe it's applicable in this instance in regard to abandoned capital projects? And to refresh your memory, I believe it involved the construction work in progress, and you were talking about a dollar in, dollar out, essentially.
Yep, sorry, Judge, I just had to get to the right reference point here. You know, as we think about income taxes, we think about, you know, taxable income, we think about the net, you know, our revenues less our expenses. And if we think about abandoned capital projects, if we recover those costs, we get revenues equal to that recovery, and we have costs equal to the costs. Our costs will equal our revenues. Contribution to taxable income is zero as a result, and therefore there are zero income tax consequences resulting from the net of those two numbers, equaling, of course, zero.
I think I probably should have asked, the more articulate question I probably should have asked is, it has been proposed that these abandoned capital projects don't belong here and shouldn't be recovered, and maybe should be recovered elsewhere instead of being securitized. Are there additional costs with securitization that would not be involved with handling these costs through, say, a rate case?
I guess I'd have to understand how the commission might, you know, might order or find, that we would recover those costs in said future rate case.
I see what you're saying. Okay, why don't you just explain to me then what costs, what additional costs will be incurred through securitization by securitizing these costs outside the costs of the abandoned capital projects themselves?
Yeah, as we think about, any energy transition cost, contemplated in this case, and it's Ameren, Missouri's view that an abandoned capital project retired as a result, or, abandoned as a result of retiring the Rush Island facility would meet that definition. We'd securitize those energy transition costs and incur the interest charges or the interest costs associated with that financing.
Bear with me just a moment. Are you familiar with Mr. Payne's rebuttal testimony?
Yes, certainly. I do not have it in front of me, though.
I have no further questions. Any recross from the commission staff based upon? Public counsel?
No questions at this time, thank you.
Redirect?
Just a little, Your Honor. Mr. Lansford, the judge was asking you about costs associated with including the abandoned QUIP projects in the securitization amount. Basically said it'd be the interest rate on the bonds, right?
Correct.
If the QUIP projects were recovered in a rate case and, let's say, amortized over a period of years and included in rate base, there'd be a financing cost associated with that as well, right?
That's correct.
What would be the interest rate relative to the interest rate of the expected interest rate on the securitization bonds?
The same as any other rate-based inclusion, the company's weighted average cost of capital, including income taxes.
Which is higher.
Which is higher.
Thank you, Judge. That's all I have.
Actually, I'm going to ask one more question. And I don't think you need Mr. Payne's testimony to answer this, but I am looking at the chart, and you remember there was a chart included in his in regard to work orders that were still ongoing. And I'm going to ask you, I think you're not going to need this chart. I can see you kind of wincing like you might.
Okay.
It looks like, at least in regards to one of these, it says preliminary engineering and design costs for possible construction of flue gas desulfurization scrubber system units 1 and 2 at Evergy Center. And it says first charge month is June 2008, and the last charge is July of 2021, and with a 67.41% completion. That seems like an awfully long time to keep a work order open. Why is that? Why would a work order be kept open so long? I mean, that's well over a decade.
Yeah, I don't know the specifics of that, Judge, but that is the scrubber study that Mr. Burke and others were talking about. I could only speculate, I guess, as to why we might keep it open. I mean, obviously we were, there was question as to whether or not we would scrub the facility, all the way up to, 2021 and perhaps even beyond. So I guess that doesn't strike me as odd that was open while we were continuing to evaluate whether we would scrub the Rush Island facility.
Do you know why it says that why? Do you know why that the project is deemed only 67.41% complete?
Yeah, I had I'm aware of a data request that related to that. We really didn't have a a good way to estimate. The data request was, please estimate how the percent complete of each of these projects. We don't really have a method for doing that. So in responding to that data request, we were very clear that we were taking the costs that had been incurred to date and dividing them by the total approved cost associated with that work order. Now, if that really reflects, I don't know that really truly reflects the progress, or how close the study itself is to completion. Some of those work orders could have even contained additional work beyond the studies. I did hear Mr. Burke say that the studies were near complete or virtually complete. I don't know exactly how he characterized that, but
So that 67% is really just how much of the approved budget it used up?
that's exactly right.
Okay, thank you. I have no further questions. Any recourse from commission staff?
Just one. In the study that you guys were just talking about, you referenced recalling Mr. Burke talking about it as well. Do you recall him stating that the last deliverable for that study was in 2011?
I do.
Okay, thank you. Nothing further.
Public counsel?
Thank you, no.
Any redirect from Ameren? No redirect. Okay, Mr. Lansford, you may step down again. I believe the next witness is staff's. Is that correct?
Yes, staff calls Keith Majors to the stand.
Mr. Majors, I'll remind you you're still under oath.
And I will tender Mr. Majors for cross. He has plenty of appearances over the next few days, so it's not time quite yet to enter his testimony in.
Any cross-examination from the Office of the Public Counsel?
Not at this time, thank you.
Any cross-examination from Ameren, Missouri?
No, thank you.
Any bench questions?
Yes, Judge.
Go ahead, Commissioner Holzman.
Thank you. You heard my exchange previously on the issue of the costs associated with the scrubber reports. First off, do you believe that 9 million is a historically appropriate number for a report like this? We heard testimony that it was actually 2 separate companies that did the analysis and provided information, approximately equal amounts of effort.
Right, and I think, so that would be the establishment of a work order. That work order could have accepted several other different types of charges, like internal labor, other third-party costs that would have been charged to that work order. I don't necessarily have a breakdown of the 9 million. So, I guess to answer your question, I don't know that I really have a basis of comparison for other like-kind studies, engineering studies of a potential scrubber system. So I really wouldn't have a basis of comparison to say, is 4.5 million per study an accurate number?
Do you agree that those reports and the analysis feedback they've provided give us an accurate view of what those scrubbers would have cost the ratepayers had they been installed?
I think I would. Yes, they would. I think Ameren had, and I mentioned this in my SIR rebuttal, that to evaluate the readiness of Ameren in the remedy phase, they had engaged another engineering firm, which is kind of the big 3 in what I would call the big 3 in the utility landscape. It's Sargent & Lundy, to evaluate whether or not what the time frame of the scrubbers completion would be should the court order that. In that report, which is attached to Mr. Seaver's rebuttal testimony, it was completed by Mr. Kenneth Snell. That he was engaged by Ameren to evaluate the scrubber timeline at the time of the remedy phase, and so he discusses his view of what the actual costs would be. So In terms of the timeline and the accuracy of just the cost information, that might be, that study, which was done in the context of the court remedy phase, might have more updated numbers than the figures from 11 and 8 that were the $9 million. I guess what I'm getting at is I'm going to make, I wouldn't be surprised if Ameren relied on that information as well, since it's another expert they hired to determine the cost estimates.
Do you think absent the report for $9 million, we would have a clearer picture of what's in the best interest of the ratepayers?
Well, those studies are over 10 years old, so obviously the cost information would have had to have been updated. So whatever was given to Mr. Michaels for the modeling wouldn't solely rely on that old data. So just,
Well, we talk about, prudency being an ongoing thing, but at the point in time that the reports were initiated, do you believe that they were in the best interest of the ratepayers to have that data at that time?
oh sure, we're not challenging, I'm not challenging, staff's not challenging prudence of obtaining those studies and then charging them to the project at the time they were incurred. I think the question is it appropriate to charge, well, one, their expert, I mean, Ameren's expert in the remedy phase said that the studies wouldn't necessarily save any time, that whatever owner's engineer you'd have to engage would have to evaluate what was actually done in the studies. I mean, I'm not going to say that there's no value there, but certainly the value came under question under Ameren's own expert that evaluated those studies. And so I would question the relevance and the appropriateness to securitize those costs. And I guess if I may, to Mr. Lansford's point, I think what you asked him, there's really no other way, in my mind, to recover those studies other than through securitization. If you just carry those through to the rate case, I think my argument would be they're not used and useful, they're never used and useful. And certainly, I can't think of an example where you would put, in that case, they would be abandoned costs.
So you're saying that since they were completed in 2011, they were never brought forward to be rate-based in a rate case because they would have been disallowed because they were not used and useful?
I think right now they would have been disallowed because they're not used and useful. If you built the scrubbers, I think we would probably evaluate them. We would evaluate them. I don't know how we would treat them because you'd have to redo that information.
What we do know is that they were not brought forward. They have not been included in any rate base to date, correct?
That's correct. They're not in rate base. They're in construction work in progress. The only avenue right now to recover those, other than setting up an amortization of future rate case, is through the securitization. And I think, well, the commission did authorize some CWIP amounts for in the securitization case for Empire. I mean, just to be clear, but I think these are different because there's somewhat of a cosmic irony for including costs for scrubber studies. That's kind of the reason why we're here, is because you didn't get the proper permitting. You didn't complete the scrubbers. You were never really going to complete the scrubbers going forward. Let's say that they prevailed on the NSR litigation. There was no certain plans to install those scrubbers. I think the opposite is true for the other CWIP line items. Those are in, I believe, Mr. Payne's rebuttal testimony, but they're in a data request as well. I think that's the separation. That's the real difference in my mind.
Could an argument be made then that the two reports saved the ratepayers money by instructing Ameren that it wasn't cost effective to move forward with scrubbers? thus leading us to this place where we are securitizing 15 years of depreciation?
That's not an unfair statement. They assisted them. They would have had to assist in the part. And I'm not going to dispute Mr. Burke's testimony that they did use those in the economic analysis.
Tell me a little bit about the 3.9 million that staff is recommending in this 4A. What do you attribute that? Why are you agreeing to that? What does that represent?
So I mean, I think it would be fair if there was no evidence that they were not going to complete these projects. I think it's fair to include, and barring any legal argument, which I noted, I'm not an attorney for the CWIP argument on whether or not it can be recovered. But barring that, I think there was a reasonable view that those were ongoing projects that they would have installed. They ceased completion of those projects. So in that regard, they did save ratepayers money because they stopped the projects and they did not complete them because they knew they were going to retire the plant. And so I think that's a fair argument why you would include them in securitization.
Does staff have a record of when they were informed that this plant was going to be retired? Do we know what year that was?
I think that's probably a question for Ms. Eubanks. I think we have been notified that they made a filing before the court in 21 that they, as opposed to installing the scrubbers, they intended on closing the unit, and they gave that option to the judge. And so I believe it would have been in 21. On whether or not when they informed staff, that could have been in a somewhat earlier IRP meeting, but it really hinged on the decision was related to the litigation.
Okay, one final question. Oftentimes, commission decisions signal potential future behavior, and certainly we can look at Asbury as to the past for some of the things that we decided in there is a bit of a marker. Do you believe that disallowing the report, the $9 million in the report, would encourage or discourage future retirements?
I thought you might ask me that question. I don't know that it would really encourage or discourage future retirement. Certainly, this isn't an isolated event that you have abandoned cost. First of all, comes to mind, I think there's $100 million of Callaway 2 costs that were written off in the 80s. There was the combined operating license cost. I believe those were also written off when Ameren was seeking a second unit in the last couple decades at Callaway. And so I really wouldn't view this as an isolated event, and I don't know that it would particularly, I mean, maybe Mr. Burke would have it. Well, I know Mr. Burke would have a different answer, but I don't think it would encourage or discourage in terms of retirements.
So based on that response, are you assuming that the $9 million for the reports are still on the books, that could potentially be a tax liability?
Well, they're certainly on the books in construction work in progress. In terms of tax.
Well, you said that you gave examples of when other amounts were written off. I assume when you say written off, you're talking about deducting it from your tax.
I think there might be a tax deduction there, but comment was more written off as in it's no longer asset on the books and records.
I see. Okay. Not literal. You're saying they let it go. It's not necessarily a tax deduction.
Right. I'm not commenting on abandoned plant. It would just be this is no longer a 107 CWIP. You can no longer, if you're never going to capitalize it, it's never going to come to fruition.
Right.
Then you're going to have to write it off at some point.
Okay. All right. Thank you very much. Thank you, Judge.
Thank you, Commissioner. Any other commission questions? I hear none. I have a few questions for you. Now, you're here on both issues A and B. Is that correct?
Yes, sir.
Okay, that's what I thought. Now, the scrubber study out of the abandoned capital projects, and let me pull up, that was the only item on that chart that I had questioned Mr. Lansford about that is in Mansell Payne's testimony. You're familiar with that chart?
I am, yes. I think it has the same information, but it's a facsimile of that chart right here. I don't have Mr. Payne's testimony, but I have more of a detailed accounting of the, more of a detailed description of the items.
Okay, well, you picked one item off of that chart and said that you disagreed with, you agreed with OPC or with Public Counsel that that item should be removed, correct?
Right.
And I'm going to come back to that in just a second. I want to talk about the other abandoned capital projects for a second and just ask you to explain what's the rationale for having customers pay through securitization for projects that were never completed. I mean, it doesn't appear that the customers or that the ratepayers would have received a benefit.
I think had the projects, there's no evidence that I can see that the projects, at least not the scrubber studies, the other projects had a reasonable probability of being completed because they were actively charging costs of those projects. So I think the rationale would be that the company did ultimately save ratepayers money because they stopped the projects. Let's say that you're going to close the plant October 15th, and they made a decision January 1 to stop charges to these projects and abandon them. If they had not made that decision and they had included charges through, let's say, June 30th of this year, that would have ultimately increased the net book value that they would have been asking ratepayers to pay for through securitization, the additional charges to complete the project. So, for example, looking at Rush Island Unit 2 warm-up guns and igniters. So, and that's at the time it was abandoned, it was $427,000. So, let's assume that you would have had another $200,000 of charges for, in my example, the first 6 months of 2024. Well, those would have been retired October 15th, so you would have been charging ratepayers an extra, in my example, $200,000 that since they made this decision, they would not have been having to pay for. And so it's a cost-saving measure in that regard.
Let's move on to a second to the scrubber study. Thank you for answering that for me, by the way. You indicated you would not include the scrubber study, and you provided a couple of rationales for that. And one is that it was a preliminary engineering and design cost for something that I guess never occurred. Is that correct?
Right, it really never projected to occur in the near time frame.
And also because you said, how useful could a 13-year-old study be? Is that correct?
Right.
You were in the court, or you were in the courtroom when Mr. Burke was testifying. Is that correct?
That's correct.
And Mr. Burke was explaining the potential future utility of this study. Did Mr. Burke's testimony change your mind in regard to aspects of this study?
Well, I'm not going to dispute. I respect Mr. Burke, and he's an engineer, and I'm not going to dispute. I respect his opinion on the studies. I guess, well, no, it didn't particularly change my mind. And two, I would go back to Ameren's expert, who you have an expert study you have an expert making a study about studies. It is kind of odd, but his study, the expert study, said that those studies, the $9 million, wouldn't substantially reduce the time of constructing scrubbers, and that, as I said before, the owner's engineer would have to, I don't know to the extent that they would have to recomplete the entire study, but certainly I wouldn't be surprised if it was an owner's engineer that wasn't Black and Veatch and Shaw, they would want to spend significant amounts of money completing their own studies of the engineering and preliminary engineering of the scrubbers. So I think in that regard, I would question. Yes, they're 4,000 pages and 1,000 pages, give or take, but I would question whether or not an owner's engineer wouldn't have to redo substantial amounts of not all that work. And I think that conclusion is similar to the conclusions of Ameren's study on the studies.
Thank you. Any recross from public counsel based upon commission or bench questions?
Thank you, no.
Any recross from Ameren, Missouri based upon commission or bench questions?
Yes, Your Honor, thank you. I think in response to Commissioner Holzman's questions, talking about the timing of when these studies were done and maybe their utility in terms of helping understand what the cost of installing scrubbers might be, all those questions. You remember that?
Yes, I do.
Isn't it true that any time after these studies were done in the 2010-ish time frame, whenever they were finished or whenever the projects were stopped, any time thereafter, say over the next 5 or 10 years, EPA could have imposed different or new regulations that might have changed the company's options, or at least the economics of the company's options for controlling SO2 at its units?
Sure, I don't dispute that.
And had that happened, could have happened in 2012 or 13 or 14 or 15, et cetera, right?
That's right.
And had that happened, so because I think you said something along the lines of, and I'm not trying to misstate your testimony, but it's my memory, that those scrubbers were never going to be built, those studies were never going to be used, and that's not true necessarily, is it?
I think in the near term, they wouldn't have. I mean, of course, there's always the possibility that those are going to be. Sure, you would absolutely use those. You would utilize the studies, but with the caveat that your new owner's engineer would probably want to redo those studies.
Well, let's talk about that some more, because I don't think the answer you gave is actually reality. You said not in the near term. What if I'll give you a hypothetical. You're an expert witness, so I can ask you a hypothetical question.
Sure.
What if in 2012 or 2013, EPA had changed the rules in a way that Ameren, Missouri was unable to meet the SO2 emissions limits that it had to meet under those new rules by using SO2 allowances and ultra-low sulfur coal, and the only option it had, practically speaking, was to scrub the plant? You have those facts in mind?
Yes.
And the company at that time, I think you would agree, would look at the situation and would probably do a net present value revenue requirement analysis, like Commissioner Holzman's been talking about, and would make a decision based on those economics, right?
Yes.
And it might also depend on, at that time, what are the expectations for energy prices and what are the expectations for O&M, and all of those various variables would have been taken into account, right?
Well, I think you'd update the variables, but sure, right.
So you don't know what the answer would have been necessarily at that time had the EPA changed the rules and had the the option of scrubbing been on the table, you don't know whether or not those studies would have turned into an actual scrubber or not, do you?
No.
That could have happened any time between 2010 and 2020, 21, right?
Sure, right.
Did you hear Mr. Burke discuss the fact that the Labadie plant, its units are, I think Mr. Williams and maybe Mr. Burke's the one that used the term, but called them sister plants? Do you hear that discussion?
Yes.
And what he meant by that was they're basically the same generators and a lot of the same components. There's some differences, but they're very similar, so that, let's say that they never had to scrub Rush Island, but even in the future from today, or even in that period 2010 to 2020, that, again, EPA changed the rules or something happened such that a question about scrubbing Labadie came up, Mr. Burke indicated that these studies would have been useful for that question, didn't he?
Well, then you would want to capitalize those studies at Labadie for that scrubber project. So, I mean, you want both the $9 million now or the $9 million in the future.
You also sort of premised your questions. The judge was asking you about, I don't know, you had a discussion about the owner's engineer, and I think you mentioned it just a minute ago as well. How do you know that the owner's engineer had a Rush Island scrubber project actually come to fruition at some point? And I think you said this earlier. Black and Veatch and Shaw are sort of two of the big guns, so to speak. I don't think that's the term you used, but I think that's what you meant in this industry, right?
Well, yeah, I'm sure Burns and Mack would want in on the business too.
Sure. Sure, but since Black and Veatch and Shaw had already done the studies, how do you know that Black and Veatch or Shaw wouldn't have been chosen as the owner's engineer if a scrubber project actually came to fruition?
Well, I don't know that. I am relatively convinced that they would want to redo the studies and at least update the numbers and appropriately charge you for that.
That may be so, but isn't it also certainly possible that the time that they would need and the engineering costs that they would have to incur to review their own work and perhaps update or review it would have been less than if you were starting from scratch? Isn't that certainly likely?
There's a potential for that. Sure, I'll agree with that.
Thank you, Judge. Those are all my questions.
Any redirect from staff?
Yes, and I hope it's relatively brief. Do you recall in the questions you had from the bench, you had a discussion with Commissioner Holtzman about if including or not including these studies would encourage future retirements? Do you recall this?
Yes.
How big of an incentive do you think the securitization statute provides in encouraging retirements?
Not a utility, so I couldn't give you really a utility perspective. I think it's a tool. It's a valuable tool. Certainly, our analysis and the company's analysis shows that in the long run, and this is a unique circumstance because you have to go close the plant. I think in the long run, it's a better value proposition for customers to finance at a long-term debt rate as opposed to weighted average cost of capital. Maybe with all the difficulty that, perceived difficulty Ameren has had in this case, maybe they won't want to do a securitization case in the future. I don't know. But I think part of the incentive is that they get the money up front, the $500 million in this case. So, I mean, and they can reinvest that and earn a rate of return on that, which they appropriately should. So I don't know that it necessarily reduces their incentive because again, these are special circumstances. Obviously, you didn't have a $9 million, well, at least I'm not aware of, you didn't have a $9 million chunk of money at Merrimack that was included in rates, and it wasn't securitized. I don't know of any other examples where a retirement occurred that you had a large chunk like that in CWIP. So I don't know that it's a great impediment or incentive in that regard.
Just to clarify, are you saying that 9 million out of the amount being securitized in this case is a big chunk?
Well, I think it's a large chunk compared to the rest of CWIP. When you compare it to the overall, let's see, 9 million divided by 500. No, I don't know. There's an on button here. Let's see. 5 million would be 1%. 10 would be 2, so under 2% of the total securitization. I mean, with 500 million is a nice round number, so.
And the perks of getting that 98% up front, don't you think outweigh or would you have an opinion on if that would outweigh the 2% that maybe you miss out on every now and again because of a quit project?
I am sure that the company would disagree with me but that would, I mean, they're getting 98% of their ask. I mean, that's a lot more than they usually get in the rate case ask. That's for sure, so.
When you were discussing the quit projects, do you recall discussing with the judge the types of projects that you did include in this case versus the one study that you did not include?
Yes.
Do you recall if any of those other projects were related to different regulations than the study that you did kick?
Right. The second largest project was related to requirements under the Clean Water Act. So that's certainly ongoing. You know, I don't know whether or not those projects would have been completed. I think a lot of that is the intake and the outflow of water from whatever body of water Rush Island is adjacent to, either the Missouri River or the Mississippi. I'm not sure about my geography there. But that was related to another environmental improvement.
Do you recall discussing with the bench? I think the quote that was picked out of yours was how useful could a 13-year-old study be? Do you recall that?
Right. I think that was out of my rebuttal testimony.
And there was discussion of Mr. Burke's testimony today about the study being used in other cases or in the future. Do you recall that?
Yes.
Do you know if Ameren is planning on building any scrubbers soon?
Oh. Not that I'm aware of.
And finally, you had a conversation with counsel for Ameren about if the EPA had, in the years, if in the years in between, while that study was being completed and after it was concluded, if they had gone back and changed the rules that did require scrubbers, if, at that point, then would we have found value in the study, or if it would have been useful? Do you recall that?
Yes.
If we followed that analogy through and Ameren, Missouri built the scrubbers, would this discussion be moot?
Well, I mean, okay.
Would the project be abandoned in that situation?
Well, no. I mean, I certainly wouldn't want ratepayers to have to pay twice if you're going to use the study for a potential Labadie scrubber project. Then I suppose there would be nothing to capitalize, because if you securitize the amount now, then you've received your $9 million, so there would be no basis that you would capitalize that account. I mean, I suppose if the thought is that those studies have a value, and if they do, then if the potential is to use those at a future time for the Labadie plant, I mean, I don't know that we would be, I'm not their external auditor, but I don't know that we would be necessarily opposed to the prospect of those studies remaining in construction work in progress. I mean, that would be a discussion they would have to have with their external auditor. But, I mean, again, I don't dispute Mr. Burke's testimony that those have the potential of being useful for some kind of future Labadie construction project.
But a project you're not aware of.
Right, no.
All right, that's all I have. Thank you.
Thank you. Thank you, Mr. Majors. You may step down. I believe the next witness is public counsels.
Thank you. Public counsel calls Manzel Payne to the stand.
Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated.
What is your name?
Manzel, M-A-N-Z-E-L-L, Payne, P-A-Y-N-E.
By whom are you employed and in what capacity?
I'm employed with the Office of Public Counsel as a utility regulatory auditor.
Did you prepare written rebuttal testimony that's been marked for identification in this proceeding as Exhibit 205?
Yes.
Do you have any changes to that testimony for it to be your testimony here today?
Not at this time.
Mr. Payne's going to testify as to other issues later, so I will not offer his testimony at this time, but I will tender him for examination.
Any cross-examination by the commission staff? Any cross-examination by Ameren, Missouri?
No, thank you, Judge.
Any commission questions?
Yes, Judge.
Commissioner Osman, go ahead.
Good afternoon.
Good afternoon.
Thank you for being here today. It says OPC's position on this is capital projects should be addressed in Ameren's next rate case where the relevancy and prudency should be assessed. Does that mean that you're not saying that at this juncture it should be disallowed?
That
If you're suggesting that the scrubber study be evaluated in the next rate case, that's not a position that you're taking that should be disallowed today then, correct? You're saying evaluated in the future?
Yes, yes.
Okay. Do you know why, is there a reason why this hasn't been asked to be in rate case before this? Like why hasn't Ameren brought these two studies into a rate case to ask them? After 2021, we've had a rate case since then. They knew that they were going to not proceed with scrubbers, at least by that point. If they were going to bring it in a rate case, why didn't they bring it into a rate case? Or why do you believe that it wasn't brought into a rate case before a future rate case?
I certainly can't talk for the company as to why they did not bring it in, but I could give a little bit of my own opinion on this
I just want
subject.
some conjecture.
I think with securitization, there's the incentive of the bond interest on top of this amount. So if the company is able to get this amount through securitization, they get the interest back on that amount. That is a part of that $500 million. If they take it into a rate case, as in when Ameren did this back in 1977 with abandoned projects, in a case then, they got their money back on those abandoned projects, but there was no return on those abandoned projects. So they got what they invested.
If these report costs were brought in a rate case, knowing what you know, do you believe the OPC would take a position on whether it would recommend to disallow?
As of what I know right now, I could see a disallowance on the 9 million of the total quip for that scrubber study.
Okay, thank you. Thank you, Judge.
Thank you, Commissioner Holzman. Mr. Payne, I have a few questions for you. I understand from public counsel's perspective, the idea of not wanting to pay bond interest on this over a term of years for these items. What I have a hard time understanding is how you decouple these items from the decision to retire Rush Island, because it seems to me that but for the retirement of Rush Island, all of these projects would still be ongoing. And now that Rush Island is retired, you certainly don't want them to finish any of these projects on a plant that is no longer going to be around. So I'm kind of, it appears to, I guess I don't understand the logic of decoupling it from the plant retirement decision when it seems so closely tied to it. And it doesn't, I mean, you're not asking that those be removed because the retirement's imprudent, correct?
That is correct.
Then why decouple them from the plant retirement decision since they're all plant specific?
I think that I think I am taking it apart from the securitization due to the fact that if it is in the next rate case, it can get amortized over a shorter period, be more beneficial to ratepayers who are not paying for the amount of these projects, and then also the bond interest on top of that. At that point, though, when it's being amortized in a rate case, say 3 or 5 years, 5 years is what happened in 1977 on Rush Island's abandoned projects then. There was no return on that, and they got their money for those investments, and it was more economical and beneficial to ratepayers because they were paying over a shorter time, and it was out of the way shorter.
So it is purely an economic decision about the ratepayers paying less.
Yes.
Do you believe the company is harmed in any way by moving these costs to a rate case as opposed to securitizing them?
No.
Obviously, they're not going to recover. If they're recovered through securitization, the company gets the money, the second the bonds are issued. And if there's a rate case that it's deferred to, there's obviously the time between now or when the bonds would be issued, and there's the time, the distance to the rate case and then through the rate case, and then the amortization on top of that as the money comes in, not all at once, but at a partial rate. So do you believe the company is harmed by moving those to a rate case?
I do not believe that they are harmed, and I think that because they're still getting paid that amount. It's just with QUIP, when it is construction work in progress, they are not getting paid for those items right now. Those costs are capitalized, they're not expensed at this time. Once they are finished, that's when it is put into rate base, and that's how you get your cost of service and rate design for these items. And that's where they're getting paid for with it when it's finished. And I don't believe that they are harmed right now because they're essentially, I'd say they're not getting harmed right now. They're going to get paid up front with the bond, or with the securitization bond, plus interest on top of that for 15 years. I just think it is economical for the other side where the ratepayer is having some benefit to paying back the company on this amount, but through an amortization of 3 to 5 years. I said 5 years in my testimony, and there's no return on that amount, and it's the company's still getting paid back for that.
Is the underlying logic that including those, including them as completed projects holds a ratepayer benefit? As opposed to abandoned projects where the benefit is more speculative to the ratepayers, if any?
I'm not sure I really followed the first question there.
I mean, if by definition a capital project is abandoned, do the ratepayers receive the benefit of the project? And I'm not a technical person. I could absolutely be wrong on this.
I'm not sure. Okay, will you say that again one more time? Sorry.
I might be able to. Is the logic there that if the project, or if these abandoned capital projects are carried to fruition, if they're no longer abandoned but are completed projects, the logic of including them in rate base and all of that is because the customers have received a benefit from those projects being completed?
Yes, I think I agree with that. Yeah, if they're carried through fruition, that there is a benefit, because I would hope that the company didn't do these projects and not want to have some type of benefit to the customer. Or I guess try to harm the customer by doing these projects. But I think right now I do not question the prudency or the company's reason on these projects. I just don't think that they should be here in securitization, and they should recover these in the future rate case.
Thank you. Commissioner Holzman.
The concept of securitization is a relatively new one. How many other cases outside of Asbury have you had a chance to review or study nationwide?
Not many. For construction work in progress, I tried to find some others around the country, and it was harder for me to do so. I don't really think I recall a specific case where I did see it.
You may not be the right witness to answer this question. I'm going to ask you anyways to see if maybe we can get to an answer. I was listening to the judge's inquiry, and it kind of made me think, are you aware of any commissions in the country who have dealt with securitization that have put conditions on the bonding that would require the interest of a certain portion of the amount to be returned to ratepayers?
I'm not aware of that, and I'm not sure I can even answer that from my knowledge, sorry.
And I don't know from a statutory standpoint the feasibility of it, but it would seem to me that that would be an interesting question to pose if someone did have the background to answer it, if a portion of the bonding could be identified or earmarked for the interest of that portion to be returned to ratepayers in some form in a future rate case.
Yeah.
If that interest could be booked for a future rate case.
Yeah, I do not have the expertise on that.
Okay, all right, thank you.
Sorry.
Thank you, Judge.
Thank you, Commissioner. Any recross based on Commissioner bench questions? Ameren, Missouri?
Maybe just a couple. How are you, Mr. Payne?
I'm doing all right. I've been a little sick the past 2 days. I'm trying to hang in.
Hope you feel better. Commissioner Holzman asked a question about why the company hadn't I guess, since 2021, when it made the retirement decision, why it hadn't sought recovery of these costs in a rate review. Do you remember that?
Yes, I do.
Do you know, from an accounting perspective, when the projects are considered to be abandoned, for example, under generally accepted accounting principles?
Not off the top of my head. at this
Might
point.
it be that the projects aren't considered abandoned until the retirement of the plant has actually been determined, exactly when it's going to happen, and that there's a mechanism for that to happen? Do you know?
I do not know off the top of my head at this point.
If these costs were included in rates in a rate case over a shorter amortization period, won't the net present value revenue requirement impact on customers be greater than if they are recovered over a longer period of time at a AAA bond interest rate?
I'd have to see the net present value calculation on that.
Do you understand what I'm saying, right? If you spread the 9 million over 15, whatever that math is, that's X amount per year, and then you've got this AAA bond interest rate. But if you spread it over 3 or 4 or 5 years, the rate impact's going to be greater. And if the rate impact's greater in those earlier years, when you do a net present value calculation, the costs in the early years count a lot more in that NPV than the costs in the later years, right? Because of discounting.
I think I follow that, yes.
You agree with that, right? That's the way.
I think so, yes.
That's all the questions I have.
Any redirect from public counsel?
Thank you. Let's start with the present value revenue requirement discussion you just had with Mr. Lowry. Would the total cost to customers be, how would the total cost to customers be? Well, let me start this way. He focused on the impact on the present value revenue requirement. What happens in terms of the total amount that customers would pay in the scenario he gave with a relatively short amortization period versus a long securitization recovery period?
Can you restate that?
What I'm trying to get at is if customers are paying, even if it's a lower rate over a longer period of time, will they end up paying more or less than if they're paying over the full period than if they're instead paying more over a shorter period of time?
I think that
Assume the same original principal amount.
I think I'm getting lost on the beginning of the question.
Okay. Let's assume we're recovering $100.
Yes.
And we have two avenues to do it. One is through a securitization over 15 years with a lower interest rate than the other option, which is a little bit higher interest rate, but over 3 to 5 years. You understand that?
Yes.
Okay. How would the total amounts compare, assuming the rate differential between the long-term payment, the 15-year payment, and the shorter term is not huge? Let's say it's 1 or 2%.
I'd say they'd pay less in the shorter term.
And then you answered some questions where, well, let's go to how the bond works. Whenever the bonds are issued, who gets the proceeds?
Ameren, Missouri.
And Ameren, Missouri is going to get some cost for servicing those bonds over time, right?
Yes.
And customers are going to pay charges that cover both the principal and interest amount on those bonds, will they not?
Judge, I think I've let this go on for quite a while, but he's just completely leading the witness, and this is redirect, not cross-examination. So I object on that basis.
That's an objection based on form, not substance. It's a technical rule of evidence, leading's perfectly permissible in proceedings such as this.
Response?
Well, he hasn't cited any law that says that, and that this is a technical rule of evidence as opposed to fundamental rule of evidence. And I certainly have had and against me have had in this room many times that objection sustained. So I'm not taking Mr. Williams' word for it that that's a technical rule of evidence.
And I don't know off the top of my head if it is. I do know that the commission is not bound by the technical rules of evidence.
I may have misstated. It's a technical rule of evidence, not a fundamental rule
Why
of
don't
evidence.
we just from this point on not lead?
Okay. In some of your answers, you indicated that the utility would, as I understood it, get not only the bond principal amount, the proceeds of the bonds, but interest on the bonds. If you did so, was that an error?
Do you know when I said that exactly? Trying to.
I think it was in response to some questions from Commissioner Holzman as well as Judge Clark.
Okay, and then will you restate that question again?
If Ameren, Missouri issues bonds, will it get interest on those bonds as well, to your understanding?
Yes, to my understanding, they'll get.
Okay, thank you.
Yes, yeah.
Mr. Payne, you may step down. Thank you. We are currently one issue away from being caught up. It would be my desire to go ahead and see how far we can get into issue 5. Just because looking at tomorrow's schedule, while the singular issues may be slightly smaller, they do cover, they are numerous. So with that in mind, I'd like to go ahead. Ms. Taylor, do you need a break? I knew it was about time. I was going to try and get by without one, but why don't we all take about 10 minutes? It's 5:19. Let's call it 5:20. Let's be back at 5:30, and we will start with issue 5. It's a lot of fives. As I indicated, off the record, it's now 5:30. It's my intention to go to 6 o'clock and see how many witnesses we can get in that time frame. It may be one, it may be more. With that, I believe the only parties with witnesses on issue 5 are staff and Ameren, Missouri. So staff, you may call your witness.
Staff calls Claire Eubanks to the stand.
Ms. Eubanks, I'll remind you, you're still under oath.
Understood. This is Ms. Eubanks' last appearance. So I would go ahead and offer her testimony, the rebuttal testimony that is Exhibit 102, and the surrebuttal testimony that is Exhibit 103.
Now, were these, I believe some of these were contained in the motion to strike, is that correct?
That's correct,
Yes.
Judge.
Okay.
So I'm assuming, there's
So,
provisional on that one.
It'll be, if we're going to do it, it will be a provisional admission subject to the commission ruling on those motions to strike.
And Judge, we did not have an objection to the rebuttal or motion to strike on the rebuttal, but we did have specific portions of the
As to this-
rebuttal. Yeah, this is Ms. Eubanks.
Thank you for clarifying that. Okay, so we are looking at Exhibit 102
Yes.
and 103?
Yes,
Is that it?
that is it.
Okay. Are there any objections to admitting Exhibit 102, the rebuttal testimony of Claire Eubanks, onto the hearing record?
Objection.
Exhibit 102 is admitted onto the hearing record. Any objections to provisionally admitting Exhibit 103, the surrebuttal testimony of Claire Eubanks, onto the record, subject to the commission ruling on the outstanding motions to strike that are being taken with this case?
No objection.
Exhibit 103 is provisionally admitted.
I will tender the witness for cross.
Any cross-examination from the Office of the Public Counsel?
Thank you, no.
Any cross-examination from Ameren, Missouri?
No, Judge.
I have some questions. And the first one is, I don't understand this issue at all. I don't understand why it's here. It's not clear to me what staff's specific issue is as it relates to the timing of the 2007 and 19 court orders. I feel like we've already discussed the harm. I feel like we've already discussed harm from the closure, so I'm not sure why we're discussing harm from the failure to seek permitting. So I'm hoping that you can explain that to me.
So I guess if I could request a copy of the issues list or position statement, because
If I can approach.
Please. I guess I would just like to know what this issue is about.
okay, so my understanding, based on what staff put in its position statement in the issue, is really more about the planning for the outcome of the litigation, as opposed to the kind of phrasing of the issues in, I think it was 1 and 3 maybe, or 3, I guess. So I think staff's position is similar. A lot of the language in the position statement, I believe, quite a bit of it is from Mr. Fortson's testimony. And then parts of it are from my testimony that we previously talked about, because the future harm is similar, and we've already discussed it under other issues.
What do you mean similar, and what is it, and where have we discussed it?
So from my perspective, the planning for the outcome, the future harm is, obviously the potential remedy that could be ordered by the court, the seasonal construct changes that led to shortfall in capacity, and Ameren's planning for those, or really the lack of planning for those, and then the transmission projects that we discussed earlier today. So we still have all the same concerns under either issue. It's just, I think we included, based on the question, a little bit more of Mr. Fortson's.
I guess based on, from a causation angle, wouldn't most of the harms that you mentioned, actually the causation be the closing of the plant and not the failure to plan for a negative outcome? I mean, because the failure to plan for the negative outcome just means you've got the negative outcome coming, which in this case forced them to make some hard choices.
So, but those hard choices were reasonably, to a certain extent at least, in my opinion, known in many, many years since, the court first ruled on at least Ameren, Missouri's understanding the law in 2016, if I recall correctly. And then the liability decision was in 2017, the remedy in 2019, and then obviously the appellate court decision in 2021. So I think from staff's perspective, they kind of went down a path and never seemed to want to move away from it.
And I get that, but if the plant doesn't close, none of those harms occur. And so all of those harms are related to the retirement of the plant, correct? What harms are produced just from the failure of to seek an new source review? That's just easier for me than getting the letters wrong.
So I think the harm is similar under both, or is the same under both questions.
So both issues caused this harm.
I think the only other difference, okay, I'm sorry. So planning for the NSR outcome, I don't know that Ameren, Missouri could have I guess the only thing I'm not sure about, is the future remedies ordered by the court.
Okay, can you explain this issue and how it relates to the timing of the various district court orders?
I think
because that seems to be the context you're tucking into.
I think it's more about the planning around the litigation's outcome, whether that be IRP planning or just planning for the eventual retirement.
And is this issue the issue that you believe most relates to staff's hold harmless provision?
Not necessarily, no. That's where it ended up in the issues list, obviously.
I interrupted you. I apologize.
No,
Go ahead.
That's okay. It's just, the issues list is what it is. I can't really speak to how all the questions are phrased or why they are where they are. But staff has three concerns, and we've talked about them all already under all the other issues.
Okay, and don't be taken aback. I'm just, like I said, I'm just trying to sort this out. I'm not,
No, I
I'm not
understand.
saying you guys picked the wrong issue. I'm not picking anything. I'm really honestly just trying to understand.
Yes.
Because I'm having some difficulty with it. So let me ask this question. Could A of this issue have fit just as easily on the plant retirement prudence issue? Or was there a reason it needs to be tied to this issue, or is there a reason it's with this issue and not with that one?
I think staff staff discussed planning for the NSR outcome in its testimony. So I suppose it was carved out as a separate issue. For some reason, I think it fits under the other one, but I don't know the reasoning behind.
Okay. Can we go ahead and go in camera? Because I'm going to ask about some confidential numbers. Okay, we are out of in camera. Is there, how does staff see this, if the commission were to grant staff's request on this and hold harmless above a certain amount? How does staff foresee that fitting into a financing order?
I think that is probably best suited for staff counsel. I would guess that, I mean, I guess if it was a CCN case, the commission can grant conditions. So if it's similar to that, you know, that would be how it would work, I suppose.
And the condition, I mean, the statute here specifically authorizes the commission to establish conditions.
Yeah, but it wouldn't be related to the securitized amount in the order, I don't think. I don't think that was the intention. It would just be a separate condition.
And I guess that's what I'm grappling with. Any recross based upon bench questions from public counsel?
Thank you, no.
Any recross based on bench questions from Ameren, Missouri?
One or two, I think, Judge. Ms. Eubanks, the judge asked you, more or less, this is staff's issue, right? He asked you that question.
I think he would like to know whose issue it was, yes.
And the answer to the question is that you raised on page 25 of your rebuttal testimony, you raised an alleged lack of planning about a near-term retirement of Rush Island and how that might relate to transmission upgrades. And Mr. Fortson filed an entire piece of testimony that claimed that Ameren, Missouri hadn't planned as I think staff thinks it should have for a possible NSR loss, right? That's the genesis of this issue, correct?
Yes, it's just we've also talked about all these issues all day today.
No, I understand that. I understand perhaps it could have been folded into, but if your testimony on that page hadn't been filed and Mr. Fortson hadn't filed his testimony, we probably wouldn't have a separate planning issue on the issues list. Isn't that fair?
I think that's fair, yes.
Okay, thank you.
Any redirect from the commission staff?
We had some questions from the bench about, you know, essentially why does this matter? Why does the timing of when Ameren was planning on how to handle the outcome of the court case matter? Do you believe that planning for a negative outcome would impact current and future plans?
Yes.
And how does timing and planning impact costs?
Well, I think we heard from one of Ameren's witnesses earlier today that costs are generally always going up.
And do you think planning for a likely negative outcome could cause a utility to invest differently?
Yes. Based on what was known at the moment in time, yeah.
I'm going to try to redirect on some of the in-camera stuff, but just avoid the numbers if we can, okay?
I will try.
You just discussed a break-even point. Do you recall that with the judge?
Yes.
When you say break-even, do you mean if the transmission costs are less than that number that we won't say? Or higher than that number that we won't say, that retrofitting may look more economical?
So we talked about the scenarios. I think a lot of people threw around the 43, 48, I can't remember exactly, scenarios. So not in all of them is it a concern. It's really more evident in a, no carbon future or a lower carbon future. And depending on how much Rush Island would have operated in the, couple years as an SSR. Or, you know, assuming that would have had more generation, which it did not. So I don't know if I'm answering your question exactly. But when I discussed earlier with the judge about, you know, when you think about, yeah, we're talking about the transmission costs, but there's also short-term capacity potentially, and the future litigation costs, that also makes it look a little less desirable. Now, that's based on the analysis and direct testimony. Mr. Michaels presented additional analysis and, I don't know, surrebuttal, and there's like 4 different analyses now, I think, so.
Do you recall when that figure that was in his direct testimony was developed originally?
So I believe it was the 2020 IRP, potentially, if I recall correctly.
Okay, we'll try to now move on from potentially sticky questions that might have in camera on them. You were asked a question about the judge, from the judge about how the financing order would address the capping transmission cost. Do you recall that?
Yes, I do.
Are those transmission costs securitized costs?
Ameren, Missouri did not include them as securitized costs in this case, no.
So is it your understanding they would not be in a financing order?
That is my understanding, yes.
And
So I guess if I may, the reason we're talking about it is Ameren, Missouri presented discussion about the projects and included the break-even and analysis in its direct testimony.
And I'm going to see if I can hopefully help maybe clarify a bit of the hesitation, because I think maybe we're talking past each other when it comes to the list of issues. Are you separating the testimony that discusses those issues from the process of how the issue is written and put on that list and in what order?
I mean, I recognize, as I discussed with Mr. Lowry, I discussed issues with planning, and Mr. Fortson discussed issues with planning. You know, support our testimony. I don't want to speak for Mr. Fortson, but I support my testimony. So staff has concerns, and I think they're valid.
But I guess, could you say some of your hesitation is that out of the collaborative process to make this issue list, you weren't necessarily, or anybody, you know, was the one to say, hold harmless goes here versus here versus here?
Oh, yes. I mean, I provided input to staff counsel's office, but the final version is, you know, I don't know how it got developed necessarily.
Okay, that's all I have. Thank you.
This is not a question, this is just a comment from me. I understand that putting the issues list together for the commission is a very difficult and onerous task. And so I wasn't in any way trying to demean that. I certainly appreciate all the hard work that all the parties do in putting that list together. So I don't want anybody to think this is about that. I'm just trying to organize and separate in my head what goes where and understand where the, I'm going to call it failure to plan issue, how that fits in with the rest of the securitization case. As I indicated before, off the record, it appears that they need to shut down the network for a few hours. So with that in mind, I'm going to, you may step down, Ms. Eubanks.
Thank you.
And I am going to adjourn for the day, go off the record, and we will take it up again tomorrow at 9 a.m. And with any luck, we will have a much cooler courtroom, and you will never hear me complain about how cold the courtroom is again.